everybody. As I've said, I know we have to get clearance before we can actually start with the case. But what we can do right now is just ask all of our three jurors, now that you've had a chance to review the rosters and everything, do you, and I know you've done this before, but to double check, do you have any conflicts right now? Okay, great.
No, you're right.
Okay, great, thank you. All right, so Jess, can I start with the swearing in and things like that, or should I wait?
Yes, give us a few minutes to verify that none of the other courtrooms have conflicts, please.
Perfect, great. And for everyone right now, I just put my cell phone into the chat room, my cell phone number. So if you do get, this goes for the jurors and also for any advocates or witnesses who are about to present anything. Say the prosecution's doing their opening and you're the defense opener and you're going to be on in 90 seconds. If you get kicked out, please feel free to shoot me a text or give me a call and say, hey, Judge, I just got knocked out. And we can make sure we hold things up. I know that I've worked with Brian and the folks that are doing all the tech stuff on this before, and they're wonderful. And I know they've got great processes too, but that helps take a step out off of their, and a piece off of their plate. You can just let me know and I'll hold up the trial. And folks, I can't stress that enough. I've probably judged 10 online tournaments since the fall, and there's lots of things that can go wrong. So particularly for you student advocates, don't sweat it. I know this is your second round. I know you made it through regionals. Don't sweat it. We'll pick it up from wherever we left off. Okay.
Your Honor, I'm just going to run upstairs to get my cell phone so
Certainly.
I have it available.
That'd be great.
Right back. Thank you.
Mm-hmm.
Judge, you are welcome to move ahead.
All right, thank you so much. Juror Gross, you are back, is that correct?
That is correct.
Wonderful, thank you. Okay, everyone, welcome. I am now going to formally call the case of the People versus Avery Becker. That's 20 CR 3103. Would the advocates and their witnesses for the prosecution please introduce themselves?
Yes, Your Honor. On behalf of Team Bolivia, the prosecution, good morning, Your Honor, ladies and gentlemen, opposing counsel. My name is Kitty Wright, and today I will be conducting the direct examination of Detective Markowitz, as well as the cross-examination of Avery Becker. Permission for my co-counsel to introduce.
They may. Thank you very much, Ms. Wright.
Good afternoon, Your Honor, ladies and gentlemen of the jury and opposing counsel. My name is Annalise Schwecke, and I will be conducting the direct examination of Alex Cifuentes, the cross-examination of Taylor Perkins, and the opening statement.
Thank you, counsel.
Good afternoon, Your Honor, ladies and gentlemen of the jury and opposing counsel. I'm Winter King, and I will be conducting the direct examination of Kyle Cusack and the cross-examination of Blake Van Owen, and conducting the closing statement.
Thank you, counsel, for your witnesses.
My name is Victoria Johnston, and I will be portraying Kyle Cusack.
Thank you.
Good afternoon, Your Honor. My name is Kenzie Firkus, and I will be portraying Alex Cifuentes.
Thank you.
Good afternoon, Your Honor. My name is Ben Harriman, and I will be portraying Detective Jordan Markowitz.
Thank you. And does that conclude the witnesses for the prosecution?
Yes, Your Honor.
All right. Let's hear from the defense. Would the advocates please enter their appearances?
Good afternoon, Your Honor, members of the jury, opposing counsel. My name is Haley Karras, and I'll be conducting the direct examination of Taylor Perkins, as well as the cross-examination of Kyle Cusack.
Thank you, counsel.
Good afternoon, Your Honor, members of the jury, opposing counsel. My name is Lily Mastrangelo, and I will be delivering the opening statement, conducting the direct examination of Professor Blake Van Owen, and conducting the cross-examination of Detective Jordan Markowitz.
Thank you, counsel.
Good afternoon, Your Honor, members of the jury, opposing counsel. My name is Caroline Cusack. I will be conducting the direct examination of Avery Becker, the cross-examination of Alex Fuentes, as well as giving the closing argument. Your Honor, at this time, may the defense witnesses now introduce themselves.
They may. Thank you, counsel.
Good afternoon, Your Honor, members of the jury and opposing counsel. My name is Donna Shaw, and I am Taylor Perkins.
Good afternoon, Your Honor, opposing counsel, members of the jury. My name is Connor Grant, and I am Professor Blake Van Owen.
Good afternoon, Your Honor, members of the jury and opposing counsel. My name is Chloe Els, and I am Avery Becker.
All right. Thank you to all advocates and witnesses for introducing themselves. We have teams Bolivia versus Ghana. What I'm going to do now is I'm going to move to the swearing in stage of the proceeding. If all of the advocates from both sides, including the witnesses, if you could please raise your hands, and you don't have to put yourself on camera. You're welcome to if you'd like. Actually, why don't we have everybody put themselves, it looks like you've all done this, you're old school at this. If you'd please raise your right hand and just answer this question after I ask it. Team members, do you promise that the presentation you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition? You can say I do. And I know all your mics are off, so we'll take your nods of your head. Great. Now just for the witnesses. So advocates, you can turn your cameras off. Thank you. For the witnesses, do you promise that the testimony you are about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition? If you agree, you can just nod your head. Great. Thank you very much, witnesses. Okay. I know that the gallery members, who include teachers and attorney coaches, they are off screen, family members included and friends. So I will just give you a gentle reminder that to please, you promise to represent yourselves as positive role models and to conduct yourselves in a manner that exemplifies ethical and professional sportsmanship during and after the mock trial round. And we thank you for that in advance. And then finally, scoring panelists, would you please raise your right hands? Thank you. And do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of this forum and competition? Thank you so much. Okay, that concludes a very important part of our swearing in. My understanding is there are no substantive motions. That's correct. And so are there any preliminary general housekeeping matters, for lack of a better word, to which the court needs to attend from the prosecution's perspective?
Yes, Your Honor. Your Honor, the prosecution requests permission to reserve time on closing for rebuttal.
Certainly, that is granted.
And the prosecution also requests that in the event of any technical difficulties, the time be stopped until the technical difficulties can be fixed.
Absolutely.
And Your Honor, finally, the prosecution asks that exhibits be constructively published to the jury only after their admission.
Sure. So are you, let me ask, if you are going to be introducing an exhibit through a witness, will you be showing that to me and to the jurors before it's entered?
Yes, Your Honor. We're asking that we be allowed to share our screen to show the witnesses the exhibits, and then we ask that it be admitted to the jury only after it is seen.
Certainly. So we'll be constructively showing it to the jury prior to its admission, and then we'll officially publish it after it's entered. And that'll go, that's granted. Thank you, Ms. Wright, and that will go for both sides.
Thank you, Your Honor.
Okay. Are there any preliminary matters from the defense?
Yes, Your Honor, a few preliminary matters.
Sure.
Your Honor, just to clarify, you have the defense's trial rosters as they were sent in chat earlier?
Yes.
And Your Honor, we ask that the timekeepers have the ability to communicate with the Zoom chat function just to avoid any time discrepancies.
Yes, in fact, I encourage that. Please, and please keep giving updates in the chat room so everybody's on the same page, literally and figuratively. Thank you.
Yes, Your Honor. Your Honor, we also ask that in the circumstance that a team member disconnects, they are able to text another team member to let the jury and the judge to let you know that they have disconnected, but that is the only time that we are allowed to communicate without the Zoom chat feature.
Is that permissible within the rules?
I will allow that. Sorry, attorney. I will allow that, but please let me know as soon as that happens as well.
Great, great. Thank you. Thank you, Bailiff Ham. Yes, so that is granted.
Yes, Your Honor. Your Honor, we also ask that the witnesses put their pronouns in chat, since in a typical court case we would have each team's trial rosters, but since we don't have that, we just ask that pronouns are put in chat.
Sure, I think that's a great idea, particularly for openings and closings, so we're not misidentifying Mrs. and Ms. and things like that. So yeah, that would be great. That's
yes,
granted.
Your Honor. Your Honor, do you and the jury have a copy of the stipulated facts?
I do. I have mine right here. And the jurors, do you have I know they have a copy of the case, so we'll assume that they do.
Yes, Your Honor. No further preliminary matters, Your Honor.
Okay, and let me ask one more question. There's no substantive motions, and I know you're the defense, so I'm not asking you to proceed with openings, but we are now, in this forum, we're now going to proceed to openings. Is that correct?
Yes, Your Honor.
Okay, great. I don't want to put anybody on the spot to present substantive motions when they're like, wait, we don't have any. Okay, and I can see all of the witnesses entering your pronouns now, so great, thank you for that. Okay, without any further ado, I think we have gone through all the preliminary matters. If, just so everyone knows, if you can keep your mics off, I'm going to mute my mic as well. And also I am going to put up during openings, I'm going to turn my camera off, so you'll just see a still portrait. And then just remind people, you can also go to speaker view in openings and closings, so you'll just see the the advocate that's presenting their opening, so they kind of get the spotlight. So if there's no other matters. Counsel for the prosecution, are you ready to proceed with your opening?
Yes, Your Honor.
Okay, you may proceed. Thank you.
Our actions prove the truth of our words. We are here to prove the defendant guilty of the actions of first-degree murder of Mackenzie Brackman and second-degree burglary of Mackenzie Brackman's home. The defendant says they are innocent of these crimes, yet you will find their words in association with their actions will be proof enough. Our story begins with Mr. Mackenzie Brackman. Mr. Brackman was a hardworking lawyer with a passion for training an upcoming generation of lawyers because Mr. Brackman was a high school mock trial coach. Mr. Brackman devoted lots of his precious time to setting the members of mock trial up for success at their competitions. However, on March 6, 2020, Mr. Brackman was murdered. Mr. Brackman was starting his long weekend when he was surprised by an intruder breaking into his home. The intruder entered the home, likely unaware that Mr. Brackman was not at work that day, found him at home, fought for control, and then used a kitchen knife to murder Mr. Brackman. You may now be asking yourself why, and you must be asking who would lash out against Mr. Brackman in such a way. The prosecution also had these questions. First, it is important that you understand the actions taken by the defendant leading up to the day of the murder. As the defendant chose to ignore guidance provided by Mr. Brackman and instead relying on natural talent when preparing for mock trial competitions, disagreements between the defendant and Mr. Brackman were common. Mr. Brackman started out by punishing the defendant and removing the defendant from the A team before the important regional tournament, which the defendant was able to return to when their best friend, Taylor Perkins, a fellow senior, immediately removed themselves from the A team as well. Then sometime after the regional tournament, the defendant took their disagreements personally and vandalized Mr. Brackman's car, writing Worst Attorney Award in permanent marker. These actions certainly seem to show the way the defendant felt towards Coach Brackman. Today, the prosecution stands before the jury with the burden of proof. It is our duty to prove beyond a reasonable doubt the existence of all the elements necessary to convict the defendant of both crimes. The elements of first-degree murder and second-degree burglary will be proven beyond a reasonable doubt through the witness testimonies and exhibits you will see today, especially the testimony of the prosecution's 3 witnesses. Beginning with an expert witness, Kyle Kuzak. Kuzak has 19 years of experience as a certified crime scene reconstruction investigator. Ms. Kuzak visited the scene after it was processed by other members of the crime lab and also reviewed the home security video footage and photographs taken of the crime scene. Ms. Kuzak will describe her investigation methods that led her to concluding there had been a physical struggle and that the intruder indeed was the murderer of Mr. Brackman. We will then hear the testimony of Alex Cifuentes, a fellow mock trial member of the defendants. Alex will recount to the jury how she exchanged text messages with the defendant prior to the murder of Mr. Brackman, where the defendant's words clearly expressed their intent to break into Mr. Brackman's home. The third witness will be Detective Jordan Markowitz. Detective Markowitz has been a homicide detective for the Denver Police Department for 7 years and has a certification in cell phone technology. Detective Markowitz's investigation included reviewing the video footage taken of the intruder, who he will describe as matching the height and build of the defendant, as well as a use of his training in cell phones to show the whereabouts of the defendant's phone the day of the crime. In addition, Detective Markowitz will show you how he came to his own conclusion that the defendant killed Mr. Brackman. The defense may try to paint the defendant as apologetic and willing to make amends with Mr. Brackman. However, Mr. Brackman chose not to engage further with the defendant. I implore you to ask yourself how any coach would relationally respond to a student who disrespected their property and person as the defendant had. When the prosecution puts together the pieces of this story, it will become apparent that the defendant's words and actions were their undoing as they eventually brought them here, where they are charged with 2 serious crimes, 2 crimes that we will prove beyond reasonable doubt. Although the defendant denies these accusations, you will see the prosecution will show that her actions proved her words.
Okay. Thank you, counsel. Counsel for the defense, would you like to proceed with your opening?
Yes, Your Honor.
Thank you.
May it please the court? Good afternoon, Your Honor, members of the jury, opposing counsel. My name is Lily Mastrangelo, and along with my co-counsel, Haley Karras and Caroline Tusek, we represent the defendant, Ms. Avery Becker. This is a case about carelessness and convenience that led to an erroneous conclusion. The prosecution rushed to come to a conclusion that is riddled with holes and that doesn't make sense. Throughout this trial, you'll hear how the prosecution consistently failed to follow clear leads and didn't even confirm Ms. Becker's solid alibi. The prosecution willingly overlooked evidence and alternate suspects. For instance, the prosecution failed to investigate Blair Rollins, a Colorado high school student whose father is in prison for life when Mr. Brackman was his attorney. Blair Rollins was also absent from school the day the crimes were committed and disappeared after graduation. This is merely one example of how the prosecution only gathered the evidence needed to make a quick and easy conclusion. The tunnel vision of the prosecution led them to a convenient conclusion rather than a correct one. What the evidence in this case will make clear is that Avery Becker did not commit the alleged crimes. The state's sloppy investigation resulted in an incorrect conclusion. And that is why the wrong person is sitting here today. The defense will call 3 witnesses. First, Ms. Taylor Perkins, who is Ms. Becker's best friend and mock trial teammate. Ms. Perkins will tell you about her observations of the relationship between Mr. Brackman and Ms. Becker, and will tell you about the fractures in this relationship. Ms. Becker will then testify that she and Ms. Becker spent the evening of March 5th together, and more importantly, that they spent the entire morning and afternoon of March 6th together. Ms. Perkins will testify that the police didn't even check her phone to confirm her location on either of those days. This creates a gaping hole in the prosecution's case. Ms. Perkins and Ms. Becker were together the entire day of March 6th. And therefore, Ms. Becker couldn't have been in 2 places at one time. Next, you'll hear from expert witness Blake Van Owen, a private investigator and a professor who teaches police practices. He will take you through his evaluation of the investigation conducted by the prosecution. He will tell you that this investigation was rushed, sloppy, and was blinded by tunnel vision. Professor Van Owen will testify to the 3 main problems in the prosecution's investigation. In his expert opinion, he will testify to 1, the uncertainty of the prosecution's claimed stabbing method, 2, the inaccuracy of Ms. Becker's location on the cell tower diagrams, and 3, that overall, the prosecution's investigation was methodologically unsound. Professor Van Owen will show you through his thorough evaluation that the inadequacy of the prosecution resulted in a conclusion that is simply incorrect. And finally, you'll hear from the defendant, Ms. Becker. Ms. Becker will tell you about her experience with mock trial and about her relationship with Mr. Brackman. And with this, she'll tell you that this relationship had its difficulties. Ms. Becker will tell you about a prior incident with Mr. Brackman's car, about her regret over the incident, and about the great length she went to make amends with Mr. Brackman. Ms. Becker will then testify that on March 5th, she and Ms. Perkins went to the Fry Shack, where Ms. Becker lost her phone and didn't realize it until the next day. Ms. Becker will then testify that on March 6th, she and Ms. Perkins spent the entire day together, retracing their steps to find that phone. And finally, Ms. Becker will tell you that she could never and would never commit these crimes. At the end of this trial, we will show that the prosecution failed to meet their burden of proof beyond a reasonable doubt. The prosecution's investigation was careless from start to finish. Members of the jury, don't let the prosecution's desire for convenience and their utter disregard for accuracy put an innocent young woman in jail. At the end of this trial, the defense will ask that you find Miss Avery Becker not guilty. Thank you.
Thank you, counsel, for your opening for the defense. Is the prosecution ready to proceed with its case in chief?
Yes, Your Honor.
All right, you may proceed. Please call your first witness. Thank you.
I would like to call Kyle Kuzak to the stand.
Thank you. Ms. Cusack?
Good afternoon. Please state your name and spell your last name for the record.
Kyle Kuzak, Kuzak.
What do you do for a living?
I am a Colorado Bureau of Investigator, crime scene reconstruction investigator, also known as CSR, and I've spent my last 3 years with the city of Denver.
What is a crime scene reconstruction investigator?
I investigate complex crime scenes, home invasions, burglaries, domestic violence, things of that nature.
How long have you been doing your job?
I have 19 years of experience in this occupation.
Your Honor, I move to qualify Kyle Kuzak as an expert in crime scene reconstruction investigation.
Any objection from the defense?
Yes, Your Honor. Permission to conduct a brief voir dire.
You may.
Good afternoon, Ms. Kuzak. Isn't it true that the main aspect of your job is the actual reconstruction of a crime scene?
Yes, that is what a crime scene reconstruction investigator is for.
And this means that analysis is only one part of your investigation, correct?
Yes, but it plays a pretty big role.
And isn't it true that crime scene reconstruction creates more investigative questions during the analysis?
It does create some, but it also helps us solve a lot of questions.
Thank you. Your Honor, I do not object to Ms. Kuzak being tendered as an expert in the field of crime scene reconstruction, but I do object to the witness being entered with a focus on analysis, as she claims herself that the analysis creates more questions than answers.
Any reply, Ms. King?
I was moving to qualify Kyle Kuzak as an expert in reconstruction investigation and not specifically analysis.
Okay, so the court will accept the tender and we will, I'm going to overrule your objection, defense counsel, Ms. Karras, but let's keep an eye on it. If you feel that the witness is going beyond the bounds of her tender, feel free to, don't hesitate to object.
Yes, Your Honor.
Thank you. You may proceed, Ms. King. Thank you.
What is your role in the investigation?
I investigated the scene of the homicide on the day of the murder, as well as reviewing the police reports, photos taken from the crime scene, and the ring security videos.
What day did the crime occur on?
Based on our investigations, March 6th, 2020.
Based on your investigation, what happened on the afternoon of March 6, 2020?
Well, this was obviously a burglary gone bad. The intruder entered through the back door of Mr. Brackman's home, which then caused the victim to grab a weapon to defend himself, and unfortunately, during the ensuing struggle, was killed with the same weapon he introduced to the encounter.
How did the suspect enter the home?
First, he attempted the front door of the residence, but when that attempt failed, he went around the back gate and entered through the back door.
Based on your investigation, did Mr. Brackman allow the intruder to enter his home?
It seems to us that it was indeed unauthorized, as Mr. Brackman had a ring security system that would have allowed him to the presence of someone at his home, and he would have easily been allowed to let the person in himself.
What happened after the suspect entered Brackman's home?
After the suspect entered Mr. Brackman's home, he was then met by Mr. Brackman, who had grabbed a weapon to defend himself, but unfortunately, during the struggle, was stabbed in the shoulder.
Your Honor, permission for the witness to view Exhibit 8.
That's granted.
Let the record reflect that I am showing the witness what has previously been marked as Exhibit 8.
Record shall reflect.
Oh, never mind. Sorry, I thought it wasn't sharing. Do you recognize Exhibit 8?
Yes, I do.
What is Exhibit 8?
It is a picture of a knife block found in the home of Mr. Brackman's kitchen.
How do you know?
This is the picture I reviewed during my investigation.
Is Exhibit 8 a complete and accurate copy of the document you reviewed during your investigation?
Yes, it is.
Your Honor, I move to admit Exhibit 8.
Any objection from the defense?
No objections, Your Honor.
Okay, Exhibit 8 shall be received and you may publish it.
What do you notice about the block?
There seems to be a knife missing from one of the slots in the knife block.
What type of knife would fit in that spot?
Most likely a large chef's knife would fit in that spot.
Let the record reflect I have stopped sharing Exhibit 8.
Record shall reflect.
What type of knife did you find to be the murder weapon?
The murder weapon was indeed a large chef's knife as well.
Based on your investigation, how was the victim stabbed?
We believe that the victim was stabbed in a bear hug-like fashion during the struggle, and when the knife entered Mr. Brackman's shoulder, it nicked the tip of his aorta, causing him to bleed internally.
Your Honor, permission for the witness to view Exhibit 18.
She may.
Let the record reflect that I'm showing the witness what has previously been marked as Exhibit 18.
Record shall reflect.
Do you recognize Exhibit 18?
Yes, I do.
What is Exhibit 18?
They are scuff marks found near the back door in Mr. Brackman's home.
How do you know?
This is the picture I reviewed in the investigation.
Is Exhibit 18 a complete and accurate copy of the document you reviewed in your investigation?
Yes, it is.
Your Honor, I move to admit Exhibit 18.
Any objection from the defense?
Yes, Your Honor. I object on lack of foundation as well as relevance. We cannot know when the scuff marks occurred, and the witness has not laid the proper foundation to how they believe that these scuff marks have occurred.
Your response, Ms. King, first to the relevance objection.
The relevance is building on the prosecution's case on how exactly the crime occurred, like how exactly it occurred, like the nature of it all. And I was going to lay foundation in questions that would be asked while the exhibit would be shown, while the exhibit is being shown.
Okay, well, let's do this. I'm going to overrule on the 402 on the relevance objection. With regard to the 602 foundation, why don't we have you ask some of those questions, just a couple right now, so we can lay that foundation and then we can receive it into evidence, okay?
What did these scuff marks suggest?
These scuff marks suggested to us that there was indeed a struggle that occurred within the house. And once the intruder had entered the back door, that is when a scuffle took place.
How did this exhibit add to your investigation?
It allowed us to further understand what took place within the house on the day of the murder.
Your Honor, I move to admit Exhibit 18.
Okay. With that foundation laid, thank you. The court will receive Exhibit 18 into evidence and you may now publish it to the jury. Thank you.
Let the record reflect that I have stopped sharing Exhibit 18.
Record shall reflect.
Your Honor, permission for the witness to view Exhibit 9.
She may.
Let the record reflect that I'm showing the witness what has previously been marked as Exhibit 9.
Record shall reflect.
Do you recognize Exhibit 9?
Yes, I do.
What is Exhibit 9?
It is a broken plate that was found in Mr. Brackman's home.
How do you know?
This plate was found at the scene of the crime, as well as I reviewed this picture in my investigation.
How does this exhibit add to your investigation?
It was able to tell us where the struggle occurred throughout the house, telling us that it sort of moved from the back door more towards the front door.
Is Exhibit 9 a complete and accurate copy of the document you reviewed in your investigation?
Yes, it is.
Your Honor, I move to admit Exhibit 9.
Any objection from the defense?
No objections, Your Honor.
All right, Exhibit 9 will be received and you may publish it to the jury.
How do you think this plate broke?
I believe that this plate broke during the struggle. when the two were fighting or struggling, my bad. One of the two must have hit the table, causing the plate to knock onto the floor, or someone could have like laid a hand on the table and sort of thrown the plate off.
Let the record reflect that I have stopped sharing Exhibit 9.
Record shall reflect.
Based on your investigation, was the home invasion planned?
We do believe this home invasion was planned, but we do believe it was intended to be a burglary, not a homicide.
How did the victim die based on your investigation?
When the victim was stabbed, the tip of the knife nicked his aorta, and when the victim removed the knife from the back of his shoulder, it caused him to start bleeding internally almost immediately and would have caused him to die before he hit the ground.
Thank you, Your Honor. No further questions.
Thank you, counsel. Cross-examination by the defense.
Yes, Your Honor. Good afternoon, Ms. Cusack. I'm going to begin by asking you a few questions about your initial investigation. Isn't it true that you arrived at the crime scene after it had been processed?
Yes, that is true.
And this meant that you had to rely on previously gathered evidence such as police reports and photographs, correct?
Yes, I took everything that I saw at the scene as well as photographs taken.
Ms. Mastrangelo, can you please share Exhibits 1 and 4? Ms. Cusack, can you please identify what has been previously marked as Exhibit 1?
Yes, this is Mr. Brackman's body in the home, in his residence.
And Ms. Cusack, can you please identify what has been previously marked as Exhibit 4?
Yes, it is a picture of Mr. Brackman's wound on the back of his shoulder.
And are these both fair and accurate representations of the crime scene?
Yes, they are.
Your Honor, pursuant to Rule 901, the witness has authenticated and identified Exhibits 1 and 4. Your Honor, I now move to enter Exhibit 1 into evidence.
Any objection from the prosecution with regard to Exhibit 1?
No, Your Honor.
Okay, Exhibit 1 shall be received and you may publish it.
And Your Honor, I now move to enter Exhibit 4 into evidence.
Okay, prosecution, any objection to Exhibit 4?
No, Your Honor.
All right, Exhibit 4 shall be received and you may publish it.
Yes, Your Honor. Ms. Cusack, please look at Exhibits 1 and 4 next to each other. The victim's right hand is not in the same position in these exhibits, is it?
No, it does not seem that the hand is in the same position.
Now, please look solely at Exhibit 4. Isn't it true that the victim has what appears to be a wedding band on his left ring finger?
Yes, there appears to be a wedding band.
Yet, these matters are not mentioned anywhere in your report, are they?
No, we did not find it necessary to dig further into that part of his life.
Next, I'm going to ask you about your theories in regard to the knife. Ms. Mastrangelo, you can stop screen sharing. You're aware that the defendant is a high school girl, correct?
Yes, I'm aware.
And you're also aware that Mr. Brackman is a grown man, right?
Yes, but that doesn't make a teenage girl any less capable.
But you claim that this high school girl disarmed a full-grown man, correct?
Yes.
You also determined, based off of the autopsy report, that the knife was lodged in the victim's scapula, correct?
Yes.
And this would have made it very hard to pull out the knife, correct?
Yes, but he was a full-grown man and...
Thank you, I heard a yes. Even considering this, isn't it true that you claimed that the already weak victim must have pulled out the blade himself?
Yes.
Next, I'm going to ask you about the missing files. Isn't it true that part of your reconstruction relied on photographs of the blood spatter at the scene?
Yes, to my belief, some of the pictures were lost after I had reviewed them.
So these photos no longer exist, right?
To my knowledge, they do.
So neither the jury nor the defense has access to those, right?
No, but I did review them as part of my investigation.
Finally, I'm going to ask you about some of the conclusions that you made. You assumed that there was no way for the victim to have been surprised by the intruder, correct?
Yes, that is true.
And isn't it true that you assumed that Mr. Brackman received alerts from the Ring doorbell app?
Yes.
But you have no physical evidence of this, right?
We do not, but we found it very likely as he had a system and it would have most likely alerted him.
So your answer is a no, correct?
Correct.
You then further assume that if Mr. Brackman received the alerts, he chose to engage the potential intruder, right?
Well, yes, anyone would try to defend themselves if there was an intruder trying to enter their home.
You're assuming that Mr. Brackman chose to engage instead of calling 911?
Well, we are not sure of how soon Mr. Brackman knew of the intruder entering the home.
Ms.
So,
Kuzak, this question can be answered with a simple yes or no. You're assuming that Mr. Brackman chose to engage instead of calling 911, correct?
yes,
And you're assuming that Mr. Brackman chose to engage instead of running out the front door?
yes,
And you're assuming that Mr. Brackman chose to engage instead of simply locking the back door?
it is possible that the intruder could have entered the back door before Mr. Brackman knew.
Ms. Kuzak, a yes or no? You're assuming that he chose to engage instead of locking the back door?
Yes,
And isn't it correct that you cannot know for certain whether the victim heard the back door open?
there's no way to know for sure, but it is most likely that he could have.
Finally, you claim that you would prefer having more physical evidence. Isn't that true?
Yes, I would prefer having more evidence in most of the cases that I work on.
And this means that you did not have all of the evidence in order to recreate all segments of the event, correct?
That is correct. I usually don't have enough evidence for any of the crimes that I investigate.
Thank you. No further questions, Your Honor.
Thank you, counsel. Redirect from the prosecution.
Yes, Your Honor. Did you find the victim's marital status important in your investigation?
No, we did not, as we found that the victim had almost a feud with a student that he used to work with, and we found that far more important than his marital status.
Who are the two main suspects in this case?
Avery Becker.
And?
Avery
Objection.
Becker.
Outside the scope of cross-examination, this question was not brought up on cross.
Response, Ms. King?
I was laying foundation to make sure that everyone knows that both of the main suspects are high schoolers.
Okay,
In this case.
I'll give you a little latitude. Good objection, Ms. Karras, but I'm going to overrule it.
Who are the two main suspects in this case?
Avery Becker is our main suspect, and further in detail, Blair Rollins, I believe.
Are they both high schoolers?
Yes, they are.
Thank you, Your Honor. No further questions.
Okay, and my understanding is recross is not permitted in this forum. Is that correct?
Yes.
Okay, great. You may step down. Thank you. And would the prosecution like to call its next witness?
Yes, Your Honor. The prosecution calls Alex Cifuentes to the stand.
Ms. Cifuentes, you have previously constructively been sworn, so you are ready to testify. Thank you.
Ms. Cifuentes, please introduce yourself to the jury by stating your name and spelling your last for the record. Ms. Cifuentes, I believe you're on mute.
My apologies. My name is Alex Cifuentes, Sifuentes.
How do you know the defendant?
I know Avery in a variety of ways. We went to school together and we were on mock trial together. Avery was actually the one who convinced me to try out for mock trial. So because mock trial is such a big time commitment, we became pretty close friends.
What is mock trial?
Mock trial is a little hard to explain, but it's basically what it sounds like: recreating trials, being attorneys, witnesses, those type of things, but without obviously actually being them in real life.
Was the defendant talented at mock trial?
Mock trial is a big thing, so there's a lot of different areas to be talented in. So preparation, work ethic, Avery wasn't super talented at those, but Avery was amazing at improvising and performing.
Let's discuss Mr. Brackman. Who is Mr. Brackman?
Mr. Brackman was our mock trial coach and a defense attorney in the area. But for me personally, he was a teacher who really cared about his students, and he was a really big role model for me.
What did you observe the relationship between the defendant and Mr. Brackman to be like?
They did not have the best relationship, to say the least. They got in arguments pretty much every single mock trial practice, and it always seemed to me like they were incredibly frustrated with each other.
Are there any particular arguments you remember?
I mean, there were a lot of arguments, but one I remember just because of how horrible it was is right after the regional tournament, Avery and Mr. Brackman got in a fight, and Avery stormed out with a permanent marker, and from what I learned later, she vandalized Mr. Brackman's vehicle.
What did Brackman do in response?
Mr. Brackman understandably removed Avery from the team completely, which made sense, but it put the team in a really hard spot because we were headed to state, and mock trial rules say you can't just substitute someone in at the last minute.
Did you ever discuss this with the defendant?
Yes, shortly after the incident, Avery reached out to me via text and asked if I'd be willing to talk to Mr. Brackman about letting her back on the team.
Did you talk to Mr. Brackman?
Yes, I did.
Did you tell the defendant this?
Yes, I told Avery right off the bat that I didn't really think that Mr. Brackman was going to let her back on the team, but that I would talk to him, and then I spoke with Avery in person after speaking with Mr. Brackman.
Your Honor, permission for the witness to view Exhibit 14?
She may.
Let the record reflect I am sharing my screen.
Record shall reflect.
Let the record reflect I am showing the witness what has previously been marked as Exhibit 14.
Record
Do you
shall reflect.
recognize Exhibit 14?
Objection, Your Honor. There were case corrections regarding this exhibit. This is not the final, most accurate copy of the exhibit. The defense does have the most updated copy of Exhibit 14 if the court would wish to see that.
Let's talk to the prosecution for just a moment. Ms. Schwecke, is this, are you familiar with the different version of this document?
Your Honor, I did not know there was an updated version.
Might there be, do you have an objection to taking a look at the version that the defense has?
No, Your Honor.
Okay. Defense, if you would like to show us what the new one looks like. Okay, so defense, am I looking at the same document but with changes on it? So left
Yes,
column,
Your Honor.
right column. Okay. Prosecution, do you have any questions before you about this document? And do you have any objection to using this document before you proceed with the rest of your examination?
Yes, Your Honor. Can the defense counsel please explain what the differences are?
Your Honor, the differences are minor, but for clarity's sake, we would request that the most recent version is displayed for the trial today. But there are minor differences such as the battery sign at the top right corner has been altered. Just for
Okay.
clarity's sake, Your Honor, we would prefer to use the most updated version.
Sure. Defense counsel, and I know this is a little bit out of character. I'm asking this question. When was this new document released for the forum, for use in the forum? Do you know?
No, I don't remember the exact time, but I do believe it was maybe over 2 months ago, I believe.
Okay. So I don't have any objection to the new document being used. However, here's what I'm going to do. Well, for the prosecution, I'm going to let you use whichever one you want. And then for the defense, you can certainly integrate the new document and show any distinguishing differences or similarities in your cross. Okay.
Your Honor, if I may,
Sure.
there was a text me app used in the first non-updated copy of the document that could play a role in the authenticity of these documents and for the creation of the text. So the most updated version, the one that is displayed on the screen right now, does not have that text me app included.
And I'm sorry, you said it has a text me. You're gonna have to edify me a little bit.
Your Honor, there's an app called Text Me, and it, I believe, gives you the ability to alter text.
Okay, and why is that relevant, counsel? Are you saying that the first version we're using was altered?
Your Honor, the first version had that app up in the top corner, which could point to the lack of authenticity of the text messages. So it's important that
I see.
the
So
new
you're
copy does not have it.
I see. So you're objecting to the first version based upon a lack of foundation. There's not authenticity. Prosecution, I'll give you an opportunity to respond to that.
Yes, Your Honor. For our case, we primarily use these statements in the text messages. If the statements are the same in the second version, I do not believe the prosecution has any objection to using the second.
Okay.
exhibit.
Okay, then that's on me. I'm making this more difficult than it needs to be, since there's no foundational response. There's no objection to using the second document. We'll use the second document. So, okay, so we'll do that. Can we take the old? Yeah, good. Take the old one off the screen. Great. Thank you. Thanks for working with me on that.
Your Honor, can the defense please show? Thank you.
Yeah, that'd be great. Thanks.
All right, let the record reflect that I am showing this witness what has been previously marked as Exhibit 14.
Okay, record shall reflect.
Do you recognize Exhibit 14?
Yes, I do.
What is Exhibit 14?
Exhibit 14 is the screenshots of the text message conversation that I had with Avery.
How do you know?
I was the recipient of these text messages, as well as the fact that I took these screenshots myself.
Is Exhibit 14 a complete and accurate printout of the text messages?
Yes, it is.
Your Honor, I move to admit Exhibit 14.
Any objection from the defense?
Yes, Your Honor. I object on the grounds of hearsay. This is an out-of-court statement made by two different declarants, as well as the fact that the exhibit as a whole is being offered for the truth of the matter asserted.
Okay, a response to the 802 objection by the prosecution.
Your Honor, the statements made by Avery Becker belong to an opposing party and are therefore not hearsay under Rule 801 D2A. And furthermore, the statements made by Alex Cifuentes are for the effect on the listener, not for the truth of the matter asserted.
Okay. On that basis, it's a good objection. This is an out-of-court statement, counsel, but it sounds like the prosecution is offering it to prove the truth of the matter asserted, but based upon both 801 D2A and that the other statements of the non-party are being used for effect, I will overrule the objection and allow receive the Exhibit 14 into evidence. Thank you.
Yes, Your Honor.
Ms. Cifuentes, can you please read the last two messages you received from the defendant?
Yes, of course. Avery texted me saying, I'm going to wait until he's at work, then break in and trash it. Trash it being in reference to Mr. Brackman's house, as you can see in the previous messages sent by Avery. And the last message was, that'll show him.
Did you share this conversation with anyone?
Only Detective Markowitz.
Ms. Cifuentes, did you fake these text messages?
No, absolutely not. I would never do that.
Thank you, Your Honor. No further questions.
Okay. Cross-examination by the defense.
Yes, Your Honor. Good afternoon, Ms. Fuentes. I'm going to start off asking you some questions about mock trial. A mock trial meant a lot to you, correct?
Yes, I love mock trial.
You worked really hard on your assignments, didn't you?
Yeah, because I was so passionate. I loved working on it.
And isn't it true that the way Ms. Becker participated in mock trial irked you?
It seemed to me from time to time that Avery didn't put a lot of work into mock trial. So because I was so passionate about it, I just kind of wanted everybody on the team to put in the same amount of effort.
And you consider yourself to be pretty equally skilled with Ms. Becker, is that right?
In our respective areas, yeah.
But you believe that she won her awards not because of any talent, but because of good looks. Is that correct?
Objection, Your Honor. Relevance.
Response to the relevance objection.
Your Honor, this is relevant as it speaks to the relationship between Ms. Becker and Ms. Fuentes, the competitive aspects within it, and it can go to bias as well.
I'll allow it. Overruled.
Could you
now, Ms. Fuentes, yes, of course. You believe Ms. Becker won her awards not because of any talent, but because of her good looks. Is that right?
I think I did say that. That was probably a little...
Thank you, Ms. Fuentes. I heard a yes. And you were envious when Ms. Becker won her awards at competition, correct?
I mean, I would have loved to get those awards. As I said, I was really passionate. So envious, yeah, I guess you could say that.
And you saw it as a slap in the face, correct?
I believe I said that it's a slap in the face when someone who doesn't work as hard wins awards in mock trial, and I was saying that more to illustrate how mock trial is unfair, not specifically in regards to Avery.
Now let's move on and talk a little bit more about your relationship with Ms. Becker. You claim you're basically best friends with Ms. Becker. Is that right?
Yes, as I said, being in mock trial together, we developed a pretty close relationship, I would say.
But isn't it true that you think criminal charges should have been pressed against your good friend after the car incident?
Objection, Your Honor. Argumentative.
Overruled.
I'm going to re-ask the question. Yes, of course. Isn't it true that you think criminal charges should have been pressed against your good friend, Ms. Becker, after the car incident?
I mean, vandalism is a criminal offense, and I kind of always want to do what's right. So even though Avery is a close friend of mine, it would have made sense.
Is that a yes, Ms. Fuentes?
It would have made sense if Mr. Brackman had pressed charges against Avery.
You claim you had a friendly competition with Ms. Becker, is that right?
Yes, we were teammates and we pushed each other to be better.
But you were excited to have Ms. Becker off the team because it meant that you would receive a larger role, correct?
I mean, in a way, but Avery was a year older.
Thank you, Ms. Fuentes. I heard a yes. And isn't it true that you really didn't see your good friend, Ms. Becker, that often outside of mock trial?
Not outside of mock trial, but mock trial is a big time commitment, so frequently.
Let's talk about March 6th. You were at the Fry Shack on March 5th. March 5th, correct?
I'm sorry, you said two different dates. Which one are you referring to?
Yes, excuse me. Let's talk about March 5th. You were at the Fry Shack on March 5th, is that right?
I believe that was the date.
Then you saw Miss Becker and Miss Perkins there, correct?
Yes, I did.
Then you even played a game on Miss Becker's phone, is that right?
Yes, Avery offered to let me play a game on her phone.
So it's true then that you had Miss Becker's phone in your possession?
Yes, for a short time.
And this was the date Miss Becker lost her phone, is that right?
I'm not sure as to when Miss Becker lost her phone.
Let's move on. I'd like to talk a little bit about your interview that you had. You got a call to go down to the police station for an interview, correct?
Yes, I did.
And you were aware you were going down for a full interview, is that right?
Yes.
So you knew that you needed to bring your phone to show the text you claimed to have received from Miss Becker, is that right?
Yes, I was aware that that was important.
But you didn't bring your phone, did you, Mr. Fuentes?
The battery on my phone sucked, and so I had plugged it in to charge it so it would be ready.
Mr. Fuentes, that's not the question I asked. You didn't bring your phone, did you?
No, because I left it charging. I just completely
Thank
forgot
you.
it.
And you sent screenshots the next day, correct?
I believe so, yes.
So when you received these text messages, you didn't call the police?
I mean, as I said, Avery was a close friend of mine, and I didn't really think that she was serious about breaking into Mr. Brackman's house.
So you didn't call the police, is that correct?
No, because I didn't think Avery was serious.
You didn't notify the school either?
No, once again, I didn't think Avery was serious. I wasn't going to get them in trouble over something I thought was just a heat.
And you didn't tell Mr. Brackman either, did you?
No, because once again, I didn't think Avery was serious.
So right when you received these text messages containing a threat against your role model, as you stated earlier, you didn't tell anyone, did you, Mr. Fuentes?
No, because I didn't think Avery
Thank you,
was
Your Honor. No further questions at this time.
Redirect examination.
No, Your Honor.
All right, the witness may step down. Thank you. Would the prosecution like to call its next witness?
Yes, Your Honor. The prosecution calls Detective Jordan Markowitz to the stand.
Okay, good afternoon, Detective. You've previously constructively been sworn, so you are ready to testify. You may proceed, counsel. Thank you.
Good afternoon, Detective. Please state your name and spell your last for the record.
Detective Jordan Markowitz, Markowitz.
What do you do for a living?
I work for the Denver Police Department. I've worked here for 13 years, and I've been a detective for 7 of those 13 years.
Do you have any specialized training?
Yes, I do. I have specialized training in cell phone technology as well as forensic data recovery, and I got these from the American Academy of Law Enforcement.
What did that training involve?
That training involved learning how to download, different types of cell phone data from a cell phone, using systems to obtain cell phone data, such as the Celebrite system, and how to download data from cell towers. And and to get these certifications, I had to complete a 3-day training course as well as pass a certification test.
How many cases have you used your knowledge of cell phones in?
I use my knowledge constantly as a detective. I've used it in over 50 cases, and I've downloaded the contents of literally hundreds of cell phones.
Your Honor, at this time, the prosecution moves to tender Detective Jordan Markowitz as an expert in cell phone technology as well as forensic data recovery.
Any objection or voir dire by the defense?
No objection, Your Honor.
Okay, the court shall so qualify the detective. Thank you.
What relation do you have to this case, Detective?
In March 2020, I was assigned to investigate the death of Mackenzie Brackman.
At what point in time did you arrive on the scene?
After uniformed officers secured the scene, I responded at approximately 2:20 p.m.
What were your first impressions of the scene?
Well, the victim, he was laying just inside the home. His upper left shoulder area was soaked in blood. His arms were stretched out, and there was a knife just in front of his body.
What did you notice about the body?
His upper left shoulder area was soaked in blood.
As you observed the body, did you recognize him?
Not immediately, but after I saw his identification, I recognized him as a criminal defense lawyer, Mackenzie Brackman.
I'd like to move on to what you did after you recognized the body. Did you at any point in time enter the house?
Yes, I did. I went around the home and entered through the back.
What did you notice upon inspection of the house?
Upon inspection, everything was in a slight disarray. I couldn't tell if that was, just the usual state of the home or from some sort of struggle, but there was nothing stolen, which I thought was peculiar.
What do you know about the victim?
He was a criminal defense lawyer. His name was Mackenzie Brackman, and I had the displeasure of being crossed by him several times.
Did you recover any information from the scene?
Yes, I did. I recovered the victim's cell phone, and I was then able to see that he had numerous emails relating to something called mock trial. I think he was a coach. After that, I obtained a list of contacts for the mock trial students from the school.
After obtaining the list of mock trial students, did you contact anyone?
Yes, I did. I contacted student Alex Cifuentes.
What information did Ms. Cifuentes give you?
Ms. Cifuentes informed me of numerous text messages that...
Objection, Your Honor, hearsay.
Counsel, your response to the hearsay objection.
Your Honor, there has not been a out-of-court statement in Detective Markowitz's testimony.
Counsel for the defense.
On...
Yes, counsel for the defense. What specific out-of-court statement do you believe is hearsay?
Well, Your Honor, the witness testified that Ms. Cifuentes informed him, and to inform someone, there'd have to be spoken word, which would be an out-of-court statement.
And what's the, outside the presence of the jury, what's the content of that information that was relayed to the detective, which you believe is hearsay?
Your Honor, the information that was relayed to the detective would be about the text messages between Ms. Cifuentes and Ms. Becker.
Okay. All right. With that, counsel for the prosecution, your response. I can't hear you, Ms. Wright. Can other people hear Ms. Wright? Ms. Mastrangelo, can you hear her? Okay, yeah.
No, Your Honor.
Thank you. I still can't hear you, Ms. Wright.
Miss Wright, if you go down to your microphone icon and click on that up caret button, you should be able to reselect your microphone.
Sure. Take your time, no rush. And we can have the timekeepers stop the clocks. I see that you'd like to respond in chat use chat to respond to the objection. I don't have an objection to that, sure. But we'll need to solve your microphone problem for you to continue. So it's okay if you need to take a minute or two to work on your audio. Bailiff Ham, while counsel is possibly typing a response, do you have any suggestions on how to fix the audio, what we can do for that?
My only other suggestion would be to leave and come back in.
Okay.
Your Honor, has there been any change in my audio?
Hey, you're back.
Yes.
Yeah, you're back. Great. Okay, so I'll read your responses. Your Honor, the witness has not testified to any direct out-of-court statement, and the defense objection is referring to what the witness could refer to farther into his testimony. It's a really good objection, defense counsel. It's really good because basically what you're saying is, hey, the foundation here, for whatever he has inferred or concluded, the foundation here is going to be an out-of-court statement. However, so I'm going to overrule it, and I'm going to give Ms. Wright a little bit of leeway here. Okay, so
Yes, Your
overruled,
Honor.
but excellent objection. You may proceed, Ms. Wright. Thank you.
Detective, what did you do after learning about those text messages?
After learning about these text messages, I asked Ms. Cifuentes if she and her parents could come in for an interview.
What information did that interview give you?
Well, I obtained copies of the text messages that I previously mentioned.
After talking to Cifuentes, did you contact anyone else?
Yes, after contacting Cifuentes, I immediately contacted student Avery Becker and asked for an interview.
Did you end up having an interview with Avery Becker?
Unfortunately, no, I did not end up having the interview. Just before the scheduled time of the interview, the lawyer that Becker's parents had hired had canceled the interview and said that all further communications would
Objection, Your Honor. Hearsay.
Counsel, your response.
Your Honor, this falls under exception 801D2, opposing party statement.
Okay, thank you. Any reply from the defense?
Your Honor, 801D2 refers to statement of party opponent, and the attorneys for Avery Becker do not fall under that exception.
You said the attorneys for Avery Becker do not fall under
Your
that?
Honor, if I may.
Sure.
In the description of 801D2, it says any statement by opposing party statement offered against any opposing party and was made by the party's agent or employee on a matter within the scope of their relationship and while it existed.
And your position, Ms. Wright, is that the statements of counsel are statements of an agent?
Yes, the statements of Avery Becker's counsel falls under agent or employee within the scope of their relationship.
Okay, and so you agree, Ms. Wright, that the out-of-court statement we're talking about is that of defendant's counsel. Do I have to understand that correctly?
Yes, Your Honor.
Okay, make me an offer. So refresh my memory outside the presence of the jury. What was the statement that was said? What was the out-of-court statement that was said?
The out-of-court statement that Detective Markowitz gave to the jury was that Avery Becker's attorney canceled the interview that was set up and said that any further action must go through them.
Okay. All right. Well, here's what I'm going to do. It's a very good objection again, defense counsel. I'm going to overrule it, though, not on the basis that the attorney is an agent or representative under 801D2, but rather the detective, Markovitz, is an expert. He's allowed to rely on hearsay. And more importantly, the court finds that this is being offered more for the effect on what the detective did next. So I know I've kind of supplanted prosecution's position. So I'm going to overrule the objection, but I'm limiting their use of it. Please let me know if you have any questions, because I know that's a little bit of a convoluted ruling. But otherwise, Ms. Wright, you can proceed.
Detective, would you like me to re-ask the previous question?
Yes, I would. Thank you very much.
Did you end up having an interview with Avery Becker?
No, I did not. Unfortunately, the lawyer contacted me and said that the interview would be canceled and that all further communications would have to go through her.
Did you take any further action after hearing this news?
Yes, I did. I obtained a warrant to search Becker's cell phone, but when I contacted their lawyer, unfortunately, the lawyer said that Becker had lost the phone and was no longer.
Objection, Your Honor. Hearsay.
Your response, Ms. Wright.
Your Honor, this falls under the same exception that I used previously.
Yeah, I think we're in similar waters here, so I'm going to make the same ruling. I'm going to overrule the objection, but I'm going to limit the use of the out-of-court statement for the effect on the receiver. So overrule.
Yes, Your Honor.
Would you like me to re-ask the question?
Yes, please.
Did you take any further action after hearing this news?
Yes, I did. I obtained a warrant to search Becker's cell phone, but unfortunately, when I contacted their lawyer said that Becker had lost the phone and was no longer in possession of it.
Now, Detective, I'd like to move on and talk about what you do with a cell phone number. What are call detail records?
Basically, when a phone, when an interaction with the phone happens, such as a call is placed or received, whether a text is sent or received, a record of this event is created and stored in a cell tower.
What do you do with these records?
Well, you can do numerous things with these records, such as see when a call was placed or received, the time of that. And you can also track a person's location.
How are cell towers used to track a person's location?
Well, basically, a cell phone is constantly reaching out to the nearest cell tower. This isn't always the case. Sometimes it'll connect to a different one, but it's programmed to connect to the nearest one, so usually it will. So based on that, based on the cell towers that the phone connected to, we can see the location of the person.
Can you explain what types of calls the phone was receiving on March 6th?
Becker's phone on March 6th was receiving numerous calls, all very short, so short, in fact, that the receiver could not have been picking up. And the calls were from another student on the mock trial team named Taylor Perkins.
Did the calls continue all day?
No, the calls did not continue all day. The calls stopped shortly after the time of the murder. We can assume that the phone was either put in airplane mode, perhaps turned off, or maybe even destroyed.
Your Honor, permission for the witness to view Exhibit 15?
You may.
Detective Markowitz, do you recognize Exhibit 15?
Yes, I do.
What is it?
Exhibit 15 is an accurate diagram of the cell towers that Miss Becker's phone connected to on March 6th.
How do you know what it is?
Because it's a diagram that I myself created.
Did you review this diagram when basing your opinion for this case?
Yes, I did.
Your Honor, at this time, the prosecution moves to enter Exhibit 15 into evidence.
Any objection from the defense?
No objection, Your Honor.
Okay, exhibit shall be received and you may publish it to the jury.
Detective Markowitz, what does this diagram show?
This diagram shows that on March 6, 2020 at around 12:45 p.m., Ms. Becker was at home at 12:45 to 12:50. They were at home, and from 12:50 to 1 p.m. they left, drove down Rock Creek to Mr. Brackman's home, and from 1 to 1:17 they were at Mr. Brackman's house.
Objection, Your Honor, lack of foundation. This exhibit does not show the path that Ms. Becker took or did not take.
Ms. Wright, your response to the 602 lack of foundation objection.
One moment, Your Honor. Let the record reflect that I'm not sharing my screen.
Okay.
Can the defense repeat their objection, please?
Sure. Would you mind repeating your objection?
Yes, Your Honor. Your Honor, I objected on lack of foundation as the witness testified to a possible path Ms. Becker could have taken, but the exhibit does not show this path that the witness testified she could have taken.
Your response, Ms. Wright.
Your Honor, this falls under Rule 1006, summary to prove content. The original call detail records were too voluminous for the jury to view in court today, so the detective has provided a summary in the diagram and is explaining what the diagram shows for the jury.
Response, Your Honor.
You may.
Your Honor, even if this exhibit is used to minimize the evidence and make it more understandable, there is no foundation for the possible path Ms. Becker could have taken shown in this exhibit.
Any final word, Ms. Wright?
Your Honor, this diagram was created based off of the call detail records that Detective Markowitz received from Avery Becker's phone.
Okay. Okay, it's a very good objection again, defense. I'm going to overrule it only because since this witness has been qualified as an expert, and I admit that it's thin, the area we're getting into is thin right now. Experts are allowed to speculate in their area of expertise. I think we're getting close to that border if this is in his area of expertise, but I'll give Ms. Wright a little latitude here. So very good objection. I'm going to overrule it though. Ms. Wright, you may proceed.
Yes, Your Honor.
Would you like me to re-ask the question, Detective Markowitz, or did you finish with your statement?
I finished with it.
To summarize, what do the call detail records for this case prove?
To summarize, the call detail records for this case prove that Avery Becker was in fact at the victim's home on the day of the murder, March 6th, 2020.
Based on the evidence provided and your experience as a detective, what do you believe happened the day of the alleged murder?
Based off of my experience as a detective and the evidence that I was given to work with, I firmly believe that on March 6th, 2020, Avery Becker broke into Mackenzie Brackman's home with the intent to burglarize, and on that day, they became a killer.
Thank you, Your Honor. No further questions.
Okay, cross-examination by the defense.
Yes, Your Honor. And Your Honor, before I proceed, may I ask for a brief time check?
Certainly. Can we get a time check for the defense?
At the moment, you have 9 minutes and 13 seconds left.
Thank you.
Good afternoon, Detective Markowitz. I'm going to start by asking you some questions about your investigation. Now, isn't it true that Mr. Brackman was a criminal defense attorney?
That is correct.
And isn't it true that this crime could have been the work of a disgruntled ex-client?
Of course.
But now you did look into any ex-clients, did you?
Can you repeat that question, please?
And now, Detective Markowitz, you didn't look into any ex-clients, did you?
No.
And now you went to the mock trial team for leads first, correct?
That's correct. At first, I found it unlikely, but of course, I had to follow up on all possible leads. So that's what I did, and it just led me in.
Thank you, Detective Markowitz. I heard a yes. So now, when you went to this mock trial team, you spoke to Ms. Fuentes, correct?
That's correct, yes.
But now you didn't speak to Ms. Becker, did you?
No.
And you didn't speak to Ms. Perkins?
No, I did not.
And you didn't speak to anybody else on the mock trial team.
Nope.
So you are basing all of your evidence on one person from the mock trial team, isn't that right?
That's correct, but I'd say the evidence is pretty
Thank you,
incriminating.
Detective Markowitz. I heard a yes. Now, Detective Markowitz, let's talk about the way in which you gathered your evidence. Now, you spoke to Ms. Fuentes, correct?
Yes,
And from Ms. Fuentes, you received text messages that were seemingly between Ms. Becker and Ms. Fuentes, correct?
that's correct.
But now these text messages, they were just screenshots, isn't that right?
Yeah, that's right.
But now, and you've received these screenshots because Ms. Fuentes forgot to bring her phone to your meeting, isn't that right?
Of course. I mean, you see it all the time. People get stressed out when they're meeting the police. It's not that uncommon for someone to forget their phone.
Thank you, Detective Markowitz. I heard a yes. But now Ms. Fuentes sent you the screenshots of these messages the next day, isn't that right?
That's right.
And now she was under the impression she had to send these screenshots as soon as possible, isn't that right?
That's right. Yeah.
And as soon as possible in a murder trial was the next day.
Maybe for her.
And now you never saw the authentic text, did you?
Well, these are authentic texts. So yes, I did.
Now, Detective Markowitz, you've downloaded the contents of literally over 100 phones, correct?
Yes, hundreds.
Using technology like Celebrite data.
Yes.
But you didn't do that with Ms. Fuentes' phone, now did you?
Well, I didn't have the phone now, did I? So of course I didn't.
You can go to Ms. Fuentes' house the next day and get it?
No, I mean, that seems a little weird. I mean, I feel like the
Thank you, Detective
screenshots
Markowitz.
of-
I heard a yes. But now screenshots of these text messages were sufficient enough for you in a murder trial, correct?
That's correct.
Now, Detective Markowitz, let's talk about the call detail records you collected. Now, you collected the call detail records from Ms. Becker, correct?
Miss Becker's cell phone number, that's correct.
And you found that Ms. Becker received many short calls from Ms. Perkins, correct?
That's correct.
And these calls were of such short duration that it's likely that they were never answered. Isn't that right?
That's right. It's not shocking to me considering what they were doing at the time.
But now Ms. Becker also received many texts from Ms. Perkins that were also unanswered. Isn't that right?
That's right.
And it's to your understanding that Ms. Becker claims to have lost her phone the day before these texts and calls, correct?
Yes, that is correct.
Now let's talk about the cell tower records you collected. Now you collected the cell tower records from Ms. Becker, correct?
Yes.
But now with cell tower records, they don't always connect to the nearest tower, isn't that right?
Not always, but most of the time they do. They're programmed to connect to the nearest tower.
But when they don't, that would be because the nearest tower is unavailable. So a phone must connect to a farther away tower that is available, correct?
Yes, that's correct.
So now you can't say for certain that Miss Becker's phone connected to the nearest tower, can you?
Well, I mean, like I said, they're programmed to connect to the nearest tower. I find it unlikely that it would have connected to any other one. But I mean, like you said, it's possible it did, but unlikely.
Thank you, Detective Markowitz. Now let's talk about the cell tower records you didn't collect. Now, you didn't collect the cell tower records from Ms. Perkins, did you?
No, I did not.
And now, if you had collected Ms. Taylor Perkins' cell tower records, you could see her location and corroborate her story. Isn't that right?
That's correct.
And now, you didn't collect cell tower records for anyone else in this case, now did you?
No, I didn't. I found it irrelevant.
Right. Now let's take a look at Exhibit 15. Ms. Karras, would you please screen share Exhibit 15? Now, Detective Markowitz, you created this document, correct?
Yes, I did.
Now, would you please draw your attention to the upper left-hand quadrant? And now there's a marked location there, Rollins' house. Isn't that right?
Yeah, I can see that.
And you marked this location yourself, correct?
I did.
And now Miss Rollins' house is in the same distance and vicinity as Miss Becker's house is to Mr. Brackman's house, correct?
Yeah, I'd say so.
But now you didn't collect the cell tower data from Miss Rollins, now did you?
No, I didn't.
Even after marking it on your diagram?
No, I did not collect his cell phone data, no.
Ms. Karras, would you please stop screen sharing Exhibit 15? Thank you. And now, Detective Markowitz, you only collected the cell tower records for a 35-minute period of time, isn't that right?
Yeah, that's right.
And now, let's talk about these cell tower records. So, with the cell tower records, you are sure that you can pinpoint Ms. Becker's location in these sectors, correct?
Yes.
And now, according to your methods, if you had collected Ms. Perkins' cell tower records, you could also pinpoint Ms. Perkins' location, isn't that right?
Yeah, I could.
And now, say if you collected Blair Rollins' cell tower records, you could also pinpoint her location in this area according to your methods, correct?
I could, but unfortunately I didn't have his cell phone, her cell phone, sorry.
Right. You didn't, did you?
No, I just said I didn't.
Thank you, Your Honor. No further questions at this time.
Thank you, counsel. Redirect examination.
Yes, Your Honor. Detective Markowitz, where did the evidence lead you to for this case?
All possible evidence led me to Avery Becker.
And Detective, who do you feel almost certain committed the crime on March 6th?
I am
Objection,
certain.
Your Honor, outside of cross-examination.
I understand, but I'll allow it.
Can you repeat that question, please?
Yes. Who do you feel almost certain committed the crime on March 6th?
I am certain that Avery Becker committed the crime on March 6th.
Thank you, Your Honor. No further redirect.
Okay, thank you. Does the witness may step down. Does the prosecution have any other witnesses it would like to call at this time?
No, Your Honor. The prosecution rests its case.
Okay. I will assume that we have constructively heard any halftime motions. So are we ready to proceed? And those, we'll presume that those have been constructively denied. Are we ready to proceed with the defense's case in chief?
Yes, Your Honor. The defense calls its first witness, Ms. Taylor Perkins, to the stand.
All right. Ms. Perkins, you've previously constructively been sworn, so you are ready to testify. Thank you.
Good afternoon, Ms. Perkins. Will you please introduce yourself to the jury?
Good afternoon. My name is Taylor Perkins, and I'm a freshman at CU Boulder.
Ms. Perkins, why are you here today?
I'm here today because I know that Avery didn't do this. She was with me the entire day.
Can you be a little bit more specific about the time that you were together?
Sure, we were together the morning, the afternoon, and up until about dinner time.
And what is the significance of this time period?
Well, to my understanding, this is the time that Coach Brackman, unfortunately, he died.
Now, let's move on and talk about mock trial. Were you on the mock trial team?
I was, yes.
Who was on the team with you?
Well, there's a lot of people on our team, but from the people here today, Alex Fuentes and my bestie, Avery Becker, were on the team.
And who was your coach?
Coach Brackman was our coach.
I know this must be very difficult for you. Let's talk a little bit more about mock trial. Did you enjoy mock trial?
I did, yes, it was super fun.
Would you say that you were good at it?
I would say I'm, pretty decent at it. I thought it was pretty good.
And was Ms. Becker good at mock trial?
Avery was amazing. I mean, it was just inspiring to watch her.
Now let's talk about some of the relationships that you had in mock trial. What was your relationship with Mr. Brackman?
Coach and I just had, a good student-teacher relationship.
And from your observations and practice together, what was the relationship like between Mr. Brackman and Ms. Becker?
Well, I would say they had an interesting relationship. I mean, they argued, but they both really cared about mock trial, just like in different ways.
Can you tell the jury about some of those arguments that you observed?
Sure. So I remember this one time we were preparing for regionals and, well, Avery came in and she went off her script, which Coach really didn't like. And, well, they argued and Coach actually moved her down to the B team. And, well, she was later kicked off of the team.
You also mentioned that you were on the mock trial team with Miss Cifuentes. What was that relationship like?
Well, Alex and I weren't close or anything, but we worked together on the mock trial team.
Now, let's talk about some of the other relationships at Colorado High School. Do you know of any other students that had a relationship with Mr. Brackman?
Yes, Blair Rollins, actually.
Was Miss Rollins on the mock trial team?
She was. She wasn't, actually. But she was really good friends with Alex, who was on the team.
Do you personally know Miss Rollins?
I don't. But everyone at CHS pretty much knew of her because, well, Coach actually lost the case that sent her dad to prison.
And is Miss Rollins in the courtroom here today?
She's not. No one actually knows where she is. She just she disappeared.
You mentioned that Miss Becker was demoted to the B team. What did you decide to do after that?
Well, I thought it over for a few weeks, but eventually decided to step down from the team.
Why did you make that decision?
It was mostly for the good of the whole team. So Avery was definitely A-team material, and if she was back up on the team itself would just have a better chance of making it to state.
Now, let's talk about the night of March 5th. What did you do that evening?
That evening, Avery had come over to my house so we could hang out a little bit, and then we decided to go to the Fry Shack.
And what happened while you were at the Fry Shack?
While we were there, some mock trial students actually showed up.
And once these mock trial members arrived, what happened?
Well, at one point, Alex actually came over to talk to us.
And what happened after that?
Well, Avery, at one point, she put her phone down on the table and left to go to the bathroom.
Once Miss Becker arrived back from the bathroom, what happened?
Well, we actually decided to go to the mall because Avery was a little down over the whole mock trial thing, and I wanted to, cheer her up.
Where did you last see Miss Becker's phone?
It was right on the table next to Alex.
Now let's talk about the day of March 6th. What happened that morning?
That morning, I texted Avery like I normally do to see if she was going to come pick me up for school, but she never answered.
What happened after that?
After that, she actually did end up picking me up for school, and I asked her why she didn't text me back, and that's when we actually realized her phone was missing.
What did you decide to do after you realized that her phone was missing?
We decided to ditch school and go look for her phone.
And where did you go?
Well, the first place we went was the mall because, we went there the night before. We burnt there pretty much the whole day looking there because we had spent a lot of time there the night before. And, well, we had to go through every single store we went through the night before, which, like I said, was a lot. So it just took up a lot of time.
And after you and Miss Becker spent the day at the mall, where did you go next?
Well, I got hungry, so we decided to head back to the Fry Shack. And at that point, I remembered her phone being on the table there.
And what happened once you arrived at the Fry Shack?
Well, we checked with the afternoon staff to see, if the phone was there, and it wasn't. And after that, some mock trial students actually showed up, it was pretty odd, actually.
What happened after they arrived?
Well, I realized, I learned that Coach had he didn't show up to practice, which was why they were there.
And at this point, do you now know why Mr. Brackman wasn't at practice?
I do. Now I know that Coach was actually, he had passed away at that point, and that's why he didn't show up.
Again, I know this must be very hard for you. Let's talk about what happened after your coach passed away. You testified that you were with Miss Becker the entire day. Did the police ever contact you?
No, they never talked to me about, how I was with Avery the whole day, and I never understood why they didn't.
Did anyone ever contact you?
Avery's lawyers, they actually contacted me, and I was shocked, to be honest.
Why were you shocked?
because Avery shouldn't have even needed lawyers. There's no possible way that she could have been involved.
How do you know?
She was with me the entire day, and we went to the mall and the fry shack, nowhere even close to Coach's house. There's just no possible way she could have been two places at once. Avery didn't do this.
Thank you, Ms. Perkins. Thank you, Your Honor. No further questions at this time.
Cross-examination by the prosecution.
Yes, Your Honor. Good morning, Ms. Perkins. Let's begin by discussing the defendant. The defendant is your best friend?
She is. Avery and I are besties.
Avery was the reason you were in mock trial?
Pretty much, yeah. I mean, I just really wanted to spend a lot of time with her.
Avery was talented at mock trial?
She was. She was a natural.
You think Avery was the best attorney on the mock trial team?
Yes. I mean, I wasn't so bad myself, but yeah.
You stepped down from the mock trial team so Avery could have her spot back on the A team?
Yeah, so Avery could have her spot back and so our team could make it to state.
Even though you were a senior last year?
Objection.
I was.
Relevance?
Counsel, your response to the 402 relevance objection.
Your Honor, I am laying foundation for the following questions that will go to Ms. Perkins's bias.
Okay, on that basis, overruled.
Would you like me to repeat my question?
Yes, please.
Even though you were a senior last year?
I was a senior last year, but mock trial wasn't super important to me.
And even though you had been on the team for 4 years?
I was on the team for 4 years, yes.
Let's talk about March 5th, the day before Mr. Brackman was murdered. March 5th was the day Avery lost her phone?
Yes.
Avery uses her phone a lot.
She does, yes. I mean, pretty much every teenager does.
So much you call it her third kidney?
Yeah, I mean, she's pretty much always attached at the hip with that thing. Only like when she goes to the bathroom does she like put it down.
You and Avery went to the fry shack together on March 5th.
Yes.
After leaving the fry shack, you and Avery spent time at the mall?
We did, yeah, and we talked a lot and, you know, we kind of did some like retail therapy, you know, like just shopping.
Avery didn't use her phone at all after you left the fry shack?
No, she didn't. Like I said, we were talking, so she was, you know, mainly focused on me.
Let's discuss March 6th, 2020, the day Mr. Brackman was murdered. Avery had not answered her text that morning?
This is true, yes.
Avery never confirmed that she was taking you to school?
No, but she showed up, so, you know, she was gonna take me to school until we decided to go look for her phone.
The morning of March 6th, Avery picked you up for school?
That's what I said, yes.
Avery noticed her phone was missing only when you brought it up?
From my understanding, yeah.
You didn't consider using the Find My iPhone program to find Avery's phone?
Well, you see, I have an Android, so it didn't cross my mind at that point to, you know, use the iPhone or the iCloud, I guess it's called. I don't really know. I just, like I said, I have an Android, so I didn't realize we could use it until after.
Ms. Perkins, I'd like to talk about your recollection of March 6th. You talked about Mr. Brackman's murder with Avery?
I did, yes. You see, we were both very upset because he was our coach, and it was really hard on both of us.
You knew your story matched Avery's when you gave your statement.
There's no story, it was what actually happened.
Finally, let's talk about Avery's final contact with the mock trial team. In an attempt to get back on the mock trial team, Avery texted everyone on the team?
Objection.
Well, I don't...
Speculation.
Counsel, your response to speculation objection.
Your Honor, this is included in Ms. Perkins' affidavit.
Response, Your Honor.
Certainly.
Your Honor, the witness cannot know why Ms. Becker did or did not do anything. Therefore, it is speculation.
I'm going to sustain the objection simply because it is in the witness's statement does not overcome the speculation or lack foundation objection. So, but you're certainly welcome to, I think this, it might actually border a little bit more on lack of foundation. So counsel, for the prosecution, if you can, you're welcome to try to lay that foundation. Otherwise, I'm sustaining the objection.
May I rephrase my question?
You certainly can.
Thank you. Avery texted everyone on the team?
I don't know if she specifically texted everyone on the team, but I know we talked about her doing it.
And that included Alex Cifuentes?
Like I said, I don't know if she texted Alex.
No further questions, Your Honor.
Okay, thank you. Redirect examination.
No redirect necessary, Your Honor.
Okay, you may step down. Thank you very much. Would the defense like to call its next witness?
Yes, Your Honor. The defense calls its next witness to the stand, Professor Blake Van Owen.
Professor Van Owen, you have previously been sworn, so you are ready to testify. You may proceed. Thank you.
Yes, Your Honor. Good afternoon, Professor. Would you introduce yourself to the jury, please?
Good afternoon. My name is Professor Van Owen.
And why are you here today?
I'm here today to show that the prosecution's investigation is faulty and unsound.
Professor, let's start with your qualifications. What is your current occupation?
As of now, I work two different occupations. I am a professor over at CU Denver of Police Practices and Social Justice, and I work as a private investigator on the side.
What does being a private investigator entail?
Most of my work is the analysis, evaluation, and interpretation of different investigations, although I often avail myself as an expert witness across district and state courts.
And how many times do you have any areas of expertise you specialize in?
I have three different areas of expertise that are relevant to this case. The first of those would be crime scene reconstruction, the second, cell tower analysis, and the third would be general police investigation tactics.
And what is your education in those fields?
I have a master's degree from Ashford University in criminal justice, which covers all three of those on a very in-depth scale. And I also consider the 8+ years of on-the-job experience quite educational.
And now, Professor, do you have any other experience in these areas?
As part of my job is the availment as an expert witness, I have been accepted as an expert in the area of cell tower analysis 5 times, crime scene reconstruction 8 times, and general police investigation tactics 12 times.
Your Honor, pursuant to Rule 702, base testimony by experts, and Rule 703, basis of an expert's opinion, I'm tendering Professor Blake Van Owen as a qualified expert in the fields of cell tower analysis, crime scene reconstruction, and general police investigation tactics.
Any objection or voir dire by the prosecution?
No, Your Honor.
Okay. The witness shall be received or qualified, pardon me, as an expert in those 3 enumerated areas. You may proceed.
Yes, Your Honor. Now, Professor, what evidence did you look at in your evaluation of the prosecution's case?
During all of my evaluations, the first place I started is the crime scene itself. So I looked at the crime scene reconstruction of Kyle Kuzak, then the evidence gathered by Detective Markowitz, and the autopsy report prepared by the state.
And what stuck out to you during your evaluation?
There were 3 fundamental issues with the prosecution's investigation.
What's the first issue?
The first issue is crime scene specific. The proclaimed stabbing method of Kyle Kuzak is simply not backed up by the evidence on the scene.
What's the second issue?
The second issue can be found when you take a step back. You can find that the evidence attempting to pinpoint Miss Becker's location is scientifically inaccurate and just insufficient to locate someone.
And the third?
The third and final issue is that on a broad spectrum, this case is methodologically unsound.
Now, Professor, let's start with the first issue about the lack of evidentiary support for the stabbing method. What is the issue with the stabbing method?
First of all, Miss Kuzak claims that the stabbing method happened after some sort of scuffle between the intruder and Mr. Brackman himself, where the intruder grappled the knife away, reached all the way over Mr. Brackman, and inserted the knife into the upper scapula.
And does the evidence in this case support that?
Unfortunately, it does not.
What evidence would that be?
The primary piece of evidence that play into this conclusion would be the Ring doorbell videos and the crime scene photos.
Let's start with the Ring doorbell videos. What did you see in those?
In the first Ring doorbell video, you can see an intruder of smaller stature relative to Mr. Brackman himself, which would have made a struggle between the two very challenging for that intruder.
And now you mentioned the crime scene photos. How does the crime scene photos go against the prosecution's stabbing method?
In those crime scene photos, you can see the actual knife that was used being something inconsistent with any other knives in the knife block.
And what is the significance of it being inconsistent?
Paired with the official autopsy report, we know that the stabbing was down in toward the aorta, and it had to have been with significant force to breach that upper left scapula, which would have only been possible as a smaller intruder, were they to be standing behind Mr. Brackman, above them, and stabbing while Mr. Brackman was unaware of their presence.
And now, Professor, is your conclusion different than the prosecution's?
Yes, it is.
And how is it?
The prosecution claims that the intruder was known by Mr. Brackman upon entry, when in reality, in that third doorbell video, we can see the intruder walking into the home through that back door, clearly not being engaged by anyone as they stepped in and walked into the home.
Now, Professor, let's move on to the second issue, Ms. Becker's location on the cell tower diagrams. Now, did you review these cell tower diagrams?
I did, yes.
Ms. Karras, would you please screen share Exhibit 15 as it has already been admitted into evidence? Now, Professor, what did you notice in your review of this exhibit?
The first thing I noticed when looking at this exhibit are those 3 different towers in 3 individual sectors that Miss Becker's phone connected to.
Now, what is the significance of these sectors?
According to the prosecution, these sectors accurately place Miss Becker's phone at a pinpointed location.
And how does that determine Ms. Becker's location?
Detective Markowitz claims that these different towers work in a way such that they are programmed so the phone connects to the closest one, when in reality that is untrue. As an expert in cell tower analysis, I can tell you that they are actually programmed to connect to the tower that has the least amount of traffic, thus making that phone call more efficient.
And now, does this diagram accurately pinpoint Ms. Becker's location?
Unfortunately, it does not. Considering those red sectors are approximately 37.7 square miles, if you extrapolate the radius of the circle of that tower, you can know that the only way that this phone is located is within that large area.
Ms. Karras, you can stop screen sharing. And Professor, do these cell tower diagrams pinpoint the person?
First of all, they don't even pinpoint the phone. They place it within such a broad area, it's impossible to verify the location with any accuracy. Additionally, according to statements from Ms. Perkins and Ms. Becker, they were away from Ms. Becker's phone, and as we know, a phone just does not place a person.
Now, Professor, let's move on to the last issue, that the investigation was methodologically unsound. What made it unsound?
What made this investigation so unsound was the lack of evidence gathered and the lack of investigation into ulterior suspects.
What evidence did the prosecution fail to gather?
First of all, the prosecution failed to gather any evidence about the Ring doorbell notifications, which could have let us know whether or not Mr. Brackman was alerted to an intruder.
And did they fail to gather any other evidence?
Additionally, the prosecution, Detective Markowitz in particular, accepted mere screenshots of a text exchange between supposedly Miss Becker and Miss Cifuentes when they had the tools well within their fingertips, using Cellbrite to accurately verify those text messages.
Now, you mentioned alternate suspects. Did the prosecution fail to look into any other suspects?
Yes, namely Blair Rollins.
Who is Blair Rollins?
Blair Rollins is the daughter of a Jonathan Rollins, a former client of Mr. Brackman's, who's now serving a life sentence in jail.
And what is the significance of that?
The significance is that Blair Rollins presents a clear connection to this case and a motive to engage in an activity with Mr. Brackman, such as this crime, that warranted investigation.
Now, Professor, did you investigate Blair Rollins?
I conducted a partial investigation, yes.
What did you find in that partial investigation?
First, I compared the yearbook photos of Rollins to Becker and noted that they were of the same build. And then I conducted some online research, and using standard investigative methods, I could not locate Rollins within the state of Colorado.
And what did you find about Miss Rollins's location on the day of the crime?
On the day of the crime, using attendance records from the school, I found that Rollins was absent, meaning they could have been engaged in this crime.
Now, Professor, do you have an expert opinion in this case?
I do, yes.
And what would that be?
In my expert opinion, across all of my fields of expertise, this case was rushed and missed police work 101.
How so?
First of all, they had the tools at their fingertips to gather important evidence in this case, yet neglected to do so. They also identified Rollins as a suspect, yet didn't investigate them at all. Ms. Cusack even claimed that there are 2 suspects to this day, yet somehow they impaneled the jury with the thought of pinning it on just one. These errors could lead to incorrect conclusions, and that is not justice.
Thank you, Your Honor. No further questions at this time.
Thank you, counsel. Cross-examination by the prosecution.
Yes, Your Honor. Let's begin with your analysis regarding the murder weapon. You believe that the suspect could have brought it onto the scene themselves?
I do, yes.
So you don't believe that the victim could have pulled a knife from the knife drawer?
I think it's pretty inconsistent with the evidence, considering there's nothing that claims that Mr. Brackman was alerted to the intruder.
You believe that you could have also obtained the tower records for the day prior to the murder in order to confirm that Becker and Perkins had been at those same locations a day earlier, but you didn't do so.
While I could have, it is important, actually it is necessary, that Detective Markowitz gathered this information, as the burden of proof rests with them.
So you didn't do so.
It is not within my job description to do so.
You also believe that the victim turning off his ring notifications would make him unaware of a break-in?
Considering that Kyle Cusack claims those notifications would have alerted him, were they to be off, it is pretty clear he would not have been alerted.
So the sound of the intruder trying to open the front door wouldn't have alerted the victim?
Not necessarily, considering Mr. Brackman could have easily been distracted far away from the front door, and a simple handle isn't that loud.
Or the sound of the intruder opening the back gate?
As it is outside through insulated walls, multiple layers of solids, it is pretty clear that that sound could not have been heard.
The sound of the intruder opening the back door?
Here's the funny thing about sliding glass doors. They are designed to be as quiet as possible to benefit the consumer. So no.
Your Honor, permission for the witness to view Exhibit 6.
That's granted.
Let the record reflect that I'm showing the witness what has previously been marked as Exhibit 6.
Record shall reflect.
Do you recognize Exhibit 6?
It is the murder weapon in this case, yes.
Is Exhibit 6 a complete and accurate weapon of the document of the murder weapon?
I'm not entirely sure what your question is asking, but it's an accurate depiction of the picture taken by Kyle Cusack in the crime lab, yes.
Your Honor, I move to admit Exhibit 6.
Any objection from the defense?
No objection, Your Honor.
Exhibit 6 shall be received.
Let the record reflect I have stopped sharing my screen.
Record shall reflect.
Your Honor, permission for the witness to view Exhibit 21.
You may.
Let the record reflect that I'm showing the witness what has previously been marked as Exhibit 21.
Record shall reflect.
Do you recognize Exhibit 21?
Yes, I do.
What is Exhibit 21?
This is a photo I prepared during my expert report in this case, depicting the way the knife was inserted into Mr. Brackman.
Is Exhibit 21 a complete and accurate copy of the document?
Yes, it is.
Your Honor, I move to admit Exhibit 21.
Any objection?
No objection, Your Honor.
Exhibit 21 will be received. You may publish it.
You're saying that this knife, may I share Exhibit 6 once again?
You may.
You're saying that this knife is similar to the pictured murder weapon in your investigation. You're saying that these two are similar, Exhibit 21 and Exhibit 6.
The purpose of Exhibit 21 is not to detail the construction of the knife, but rather to show the method of handling that was most comfortable for the intruder.
So you're saying it would be uncomfortable to hold the knife in the way the prosecution suggests?
Yes, that's true, and it's inconsistent with the autopsy report.
Is the murder weapon's handle smooth?
It appears to be, yes.
Couldn't it be held either way comfortably?
While it could, the autopsy report upon digital evaluation and microscopic examination showed that the anterior portion of the wound was smoother and had less jagged edges than the posterior, which means that the knife was actually held with the blade facing the front of Mr. Brackman as depicted in Exhibit 21.
So you're saying it could be held either way comfortably?
It could be held comfortably, but that's simply not how it was held in this occasion.
Are there any finger grooves in the murder weapon?
Therapeutic.
Objection, Your Honor, relevance.
Counsel, your response to the relevance objection.
I'm showing that the shown example of how Van Owen holds the knife could be inaccurate, as the actual murder weapon is smooth and could be held either way, as it has no finger grooves.
Okay, on that basis, I'll allow it. Overruled.
Let the record reflect I've stopped sharing my screen.
Record shall reflect.
Don't you believe that the suspect brought the weapon onto the scene themselves?
It's certainly more likely than the fact that the knife came from the home, yes.
How big was the murder weapon?
It was roughly 12 inches in length with a blade of 7.5 inches.
Wouldn't a knife of that size be quite hard to conceal on camera?
Considering the baggy clothing that the intruder wore, it would be pretty easy to conceal a knife.
In the ring security videos you reviewed, does it seem like the suspect is walking with a knife at all?
Unfortunately, I can't really tell if somebody's walking with a knife. For example, they could be walking with a briefcase if it's out of frame. You can't really tell if they're holding a briefcase as their arms are swinging just as they normally would.
No further questions, Your Honor.
Thank you, counsel. Redirect examination by the defense.
No redirect necessary, Your Honor.
All right. The defense witness is excused. Thank you.
Thank you, Your Honor.
Would the defense like to call its next witness?
Your Honor, before the defense calls its next witness, I'd like to request a brief time check.
Certainly. Could we get a time check for the defense?
Sorry, you have 6 minutes and 40 seconds left for direct.
Your Honor, then the defense calls its third and final witness, Ms. Avery Becker, to the stand.
Ms. Becker, you have previously been sworn and also provided your courteous advisement, letting you know of your rights. So you are ready to go. You may proceed, counsel. Thank you.
Thank you, Your Honor. Good afternoon, Ms. Becker. Would you please introduce yourself to the jury?
Good afternoon. My name is Avery Becker.
Ms. Becker, why are you here today?
I shouldn't be here at all. The things they're accusing me of, I could never imagine doing them, and they make me sick to my stomach.
Okay, thank you. Now I'd like to start off asking you some questions about mock trial. Why did you decide to participate in mock trial?
Well, it was just sort of one of those things that sounded really fun, and my best friend Taylor and I just decided to do it freshman year, and I loved it immediately, and I just wanted to keep doing it.
And who was your mock trial coach?
Coach Brackman.
Would you mind describing to the jury a little bit about what your relationship with Mr. Brackman looked like?
Well, he was my coach for 4 years, which is a really, really long time, and I looked up to him for a long time. We did start to argue in my senior year, though.
Okay, thank you. I'm going to ask you a couple questions about that senior year. Would you mind describing to the jury the practice after your regional competition that year?
Well, I had just won an award for best attorney at regionals, and I was really excited. And I kind of hoped that Coach Brackman would be excited too, but instead we just ended up having this stupid argument over the competition.
And How did this argument make you feel?
I felt horrible. I hated arguing with Coach, and I just felt horrible and kind of powerless and frustrated with it.
So after this argument, what happened?
Well, I like I said, I felt so horrible, so I felt like I had to get out of that room. So I left the room, and I had a marker in my hand from writing at the board, and I made the worst decision of my entire life, and I wrote on Coach's car.
And how did Mr. Brackman react when he saw this?
He was horrified, because especially when he realized that the marker was actually permanent. I didn't know it was until later, and he kicked me off the mock trial team.
And did you do anything to try and make amends with Mr. Brackman?
I did everything I thought I could to make amends with Coach. I really wanted to make amends with Coach Brackman. I texted him. I offered to pay for the damages I had done to his car. I even went to his office at the law firm he worked at to see if I could talk to him in person, but I never was able to get through to him, and then he was just gone.
Okay, thank you, Ms. Becker. I'm going to move on and ask you some questions about March 6th. Would you mind describing to the jury what happened on the morning of March 6th?
Yes, so I woke up, and I realized pretty quickly that my phone was missing because my alarm hadn't gone off that morning. So I went to Taylor's house to see if she'd help me look for it.
Did she?
She did. Taylor's my best friend, and she's so sweet. So she offered to skip school with me to help me look for it at the mall.
And how long did you and Miss Perkins look for your phone?
We looked for it all day. The day before, we had gone to the mall and walked around a bunch, and so we were just looking all over the mall, and that took hours. So from morning until evening, we were just out at the mall looking.
Do you remember the last place you had your phone?
Well, the last place I clearly remember seeing my phone was at the table at the Fry Shack on March 5th, near Alex.
Were you ever able to find your phone?
No, and this is so unlike me. I usually have my phone with me, and Taylor and I even tried calling it. We couldn't even hear it ring, like it was lost or not lost, I'm sorry, stolen or dead or something. I have no idea.
Okay. I'm going to ask you some questions about your relationships with other students. You mentioned Alex Fuentes earlier. Would you mind describing to the jury your relationship with her?
Well, Alex and I, we were teammates, and we never had like specific arguments, but I kind of got the feeling like she didn't like me very much.
Did you talk to Ms. Fuentes very often?
No, I can't remember the last time I talked to Alex outside of mock trial.
Ms. Karras, would you please screen share Exhibit 14? Thank you. Ms. Becker, did you send these text messages?
No, those don't even look like my text. I don't introduce myself at the beginning of my text, and I didn't even know where Coach lived, so I wouldn't have said I was going to his house.
Okay, thank you, Ms. Karras. Now, Ms. Becker, I just have a couple more questions for you. Were you anywhere near Mr. Brackman's house on March 6th?
No, like I said, I don't even know where Coach lives, and I was with Taylor all day at the mall.
And finally, Ms. Becker, did you commit these crimes?
No, just the thought of it makes me feel sick to my stomach, like I said, and I wouldn't do this, and I didn't do this. I didn't do this.
Okay. Thank you, Ms. Becker. I know it can't be easy for you. No further questions at this time, Your Honor.
Thank you, Counsel. Cross by the prosecution.
Yes, Your Honor. Ms. Becker, let's talk about your relationship with Mr. Brackman. Mr. Brackman would frequently tear you down.
We did argue sometimes during practice, yes.
Claiming that you were lazy.
I think he did say that at one point, yes.
This upset you?
Yeah, it was really hard arguing with Coach all the time. I definitely didn't like that we argued so much.
Did it upset you enough to damage property?
At one point, I was so upset, and I made the worst decision of my life, and I did everything I could to try to repair that.
But you did damage his property.
I didn't. I feel so horrible.
I'm sorry, Counsel, what was the basis of the objection?
Your Honor, I objected to asked and answered.
I think it got close, but I'm going to give counsel a little latitude here. Overruled.
Let's talk about the night that you damaged Mr. Brackman's property. Mr. Brackman came in and started criticizing your work.
He did. We got into an argument, kind of like we had before.
He came in right before you were about to write on the whiteboard.
Yeah, that's how I remember it. I was at the board with a marker in my hand.
So you left and you still had the marker in your hand.
I did, yes.
You then vandalized Mr. Brackman's car by writing Worst Attorney Award in permanent marker.
I did, and it's the worst thing that I've ever done in my entire life, and I feel so horrible.
So yes, you did vandalize Mr. Brackman's car.
I did, yes.
Ms. Becker, if you had used a permanent marker on the whiteboard, it would have ruined the board, correct?
I think so, yes. I don't really know.
But you were still planning on using a permanent marker to write on the whiteboard.
I mean, I thought the marker was dry erase, so I didn't realize it was permanent.
But yes, you were planning on using a permanent marker to write on the whiteboard.
Well, I was planning on using a dry erase marker. I had no idea the marker was actually permanent.
But the marker you used was permanent.
I only found out later that it was, yes. I don't know how it got there.
So after this, Mr. Brackman kicked you off of the team.
He did. He was angry, and I just felt horrible.
And Mr. Brackman ignored your attempts to apologize.
He did, and I really thought that I would eventually get a chance to apologize to him.
And this made you upset?
I was very upset. I was so horrified by the whole situation.
Finally, let's talk about your phone. You last recall having your phone on March 5th at the Fry Shack.
That's the last time I remember seeing it, yeah, on the table near Alex.
So throughout that entire rest of the evening, you did not notice that you did not have your phone on you.
Well, it had been such a hard week with me getting kicked off the team, and Taylor and I were at the mall, and I just wasn't thinking about my phone at the time.
So you did not notice that you did not have your phone on you throughout the rest of the evening?
No, it had been such a hard week after shopping. I was pretty wiped out.
It took you until the next morning to realize that you did not have your phone with you.
Yeah, I mean, after I came home from the mall, I just kind of went to bed, and then I only realized when I woke up.
So you skipped school the next day to find it with your friend Taylor Perkins?
Yeah, well, you know, Taylor's so sweet, and phones are so expensive that I was really worried about the fact that I couldn't find mine.
Did you use any resources to find your phone?
No, I was so panicked. I wasn't really thinking straight. I was just searching frantically to find my phone.
So no, you did not use any resources to find your phone.
Objection, Your Honor. Asked and answered.
You know, it has been asked. I don't think she got a clear answer, so I'll give her one more shot. I'm going to overrule it. Thank you.
So you were looking for your phone using no tools except for your memory of where you had been the night before.
Well, I haven't lost my phone the way I had at that point, so I wasn't thinking about what to use to find it. I was just searching everywhere I thought I could.
Miss Beck, you were using no tools except for your memory of where you had been the night before to find your phone.
No, I don't really know about a lot of tools to find your phone.
Miss Becker, did you end up finding your phone?
No, I have no idea where it could have possibly gone.
Thank you, Your Honor. No further questions.
Thank you, counsel. Redirect by the defense.
No redirect necessary, Your Honor.
Okay, you may step down now, Ms. Avery. The sheriff's deputies will escort you back to your cell. Does the defense have any additional witness that would like to call at this time?
The defense calls no further witnesses, Your Honor, but before the defense does rest, I'd like to confirm that exhibits 1 and 4 were entered into evidence by the defense.
Let me check my records here. Exhibit, yeah, and yeah, that looks good to me. Exhibit, yes, yeah.
Thank you, Your Honor. Then the defense rests.
Okay, the court will constructively hear a motion and constructively deny that, and we are ready to proceed with closings. Is the prosecution ready to proceed with your closing?
Yes, Your Honor.
Okay.
Our actions prove the truth of our words. Today, you have seen arguments from two sides of the courtroom, yet only one has presented you with the real truth. We acknowledge that the prosecution carries the burden of proof, which is beyond a reasonable doubt, and the prosecution has met that burden. For this trial, there are two charges against the defendant. The first charge being the action of first-degree murder. The elements of this crime include committing or even attempting second-degree burglary, and then someone dying in their company. For the crime of second-degree burglary, this includes knowingly breaking into a dwelling, which in this case is the victim, Mr. Brackman's home, with the intent to commit criminal mischief. Criminal mischief means that the defendant broke in with the intent to damage Mr. Brackman's property. The defendant's intent is proven by Exhibit 14, which is screenshots between Cifuentes and the defendant. Cifuentes was a friend of Avery's who came to testify. These screenshots clearly entail the defendant stating, "I'm gonna wait until he's at work, then break in and trash it. Wait till he sees what I do to his house." These screenshots being testified as authentic by Cifuentes, there is no doubt that there is intent within the defendant's words. This intent being the action of attempted burglary. This truly shows that our actions prove the truth of our words. The defendant planned to break into her coach's house to seek revenge, and it was the defendant who committed this crime that very afternoon. Becker had a motive. The relationship between the two had been strained. She was kicked off the mock trial team right before her biggest tournament of her senior year. Avery had been on the mock trial team for the past 4 years and was extremely passionate about the club. This would lead Becker to seek revenge by trashing his house while he was away. As the victim heard the intruder attempting to enter the dwelling, he grabbed a knife from within his kitchen. Whether this be the knife block with a convenient space left within or the drawer full of assorted knives within his house, which later became the murder weapon. This then led to a physical struggle between Avery Becker and Mr. Brackman, as shown by Exhibit 9, a broken plate, and Exhibit 18, scuff marks on the floor. Detective Markowitz testifies to cell tower records showing that the defendant was at the scene of the murder at the time. The bias of Taylor Perkins should also be taken into account, even stating Avery was an inspiration to her during trial. Also, Becker claims she conveniently lost her phone before the crime occurred. This would be suspicious for someone whose phone is their third kidney. Taylor Perkins even testifies today that Avery constantly is using her phone and even says she only puts it down when she goes to the bathroom. Her losing her phone would have it be impossible for authorities to verify what was on her phone around the time of the murder. I would like to remind the jury that this is a case of murder in the first degree, something that must be dealt with in the correct manner and swiftly. Someone's life has been lost due to the actions of the defendant, and the appropriate actions must be taken in order to find justice. I ask the jury to find a defendant guilty of murder in the first degree, as well as second-degree burglary. The defendant's actions truly prove the truth of her words. Thank you, Your Honor.
Counsel. And all your remaining time has been reserved for rebuttal, as we did at the beginning of the trial. Would the defense like to proceed with its closing argument and summation?
Yes, Your Honor. May it please the court? Your Honor, members of the jury, this is a case about how careless investigations lead to erroneous conclusions. The prosecution claims Ms. Becker is here because the evidence points to her. Let's take a look at their evidence. They're fragmented, mismatched, sloppy evidence. Now we know Ms. Becker wasn't at school on March 6th, 2020. Ms. Becker testified to it because she has no reason to hide it. You heard Ms. Becker testify that on that morning she'd woken up and realized her phone was missing. So she skipped school and spent the entire day looking for it with Ms. Perkins. And you heard Taylor Perkins testify to the exact same thing. You heard her confirm that truth. The problem is that when the prosecution learned Ms. Becker wasn't at school on March 6th, they had already made up their minds. It didn't matter that they also knew Blair Rollins, a viable suspect and the child of a disgruntled ex-client of Mr. Brackman's, wasn't at school that day either. They didn't follow that lead then, and they can't now. Why? Because Blair Rollins disappeared right after graduation, and to this day is nowhere to be found. And the prosecution brought 2 charges against Ms. Becker: murder in the first degree and second-degree burglary. Remember, the prosecution bears the burden of proof. They are obligated to prove every single element of the crimes charged beyond a reasonable doubt. That is a doubt that would make a reasonable person hesitate in matters of importance to themselves. The evidence and testimony you heard today shows that the prosecution failed to meet their burden and that Ms. Becker must be found not guilty. Now let's start with Detective Markowitz, who got locked in with tunnel vision on one person from the very beginning. Detective Markowitz testified that she began her investigation looking into mock trial students. But how many students did Detective Markowitz investigate before he locked in on Ms. Becker? 1. After interviewing that one student, Detective Markowitz decided he didn't need to keep investigating. In fact, the only thing Detective Markowitz looked at were screenshots of a text conversation. Detective Markowitz didn't find it necessary to provide any means of authentication on these screenshots, but rather took the word of the one student he interviewed without a second thought. The student was Alex Fuentes, the same Alex Fuentes who saw Avery Becker's success as a slap in the face, the same Alex Fuentes who just so happens to be the last person seen in possession of Miss Becker's phone. None of that mattered to Detective Markowitz. Didn't raise any concerns in his mind because he found his convenient conclusion, and he never looked back. It only takes one hole to sink the prosecution's entire case, but Professor Van Owen provided many, like the prosecution's inability to pinpoint Miss Becker's location with absolute certainty. The prosecution still tried to justify their erroneous conclusion with another careless investigation. You heard the prosecution's crime scene reconstructionist, Ms. Kuzak, claim that her investigation is thorough, but no amount of flowcharts and spreadsheets can hide 2 very important things. 1, that during her investigation, Ms. Kuzak failed to take vital observations like a wedding ring on Mr. Brackman's hand into consideration. And 2, that Ms. Kuzak failed to acknowledge that the body positions of Mr. Brackman's body were varying in the pictures that she analyzed. Ms. Kuzak is not in the business where sloppy work is ever acceptable, and yet here we are as a direct result of her sloppy work. After the countless paths leading them elsewhere, the prosecution still decided it should be Avery Becker who sits here today. Why? Well, for 2 reasons. Because the prosecution cherry-picked the evidence they wanted to examine, and because they predetermined the path of least resistance. Members of the jury, there are too many loose threads, too many unanswered questions for Miss Becker to be convicted of the alleged crimes. It is wrong to send an innocent person to jail. Sending that person to jail based on rushed investigations and inconclusive evidence, that is unjust. And there's been enough injustice in this case as the prosecution arrived at their erroneous conclusion after favoring what is convenient over what is true. As the prosecution failed to meet their burden, the defense asks you to find Avery Becker not guilty. Thank you.
Okay, thank you very much, counsel. Rebuttal by the prosecution.
Yes, Your Honor. Today, the defense calls the prosecution's investigation sloppy. However, it was proven many times that the defense was extremely sloppy in their case findings. Van Owen criticizing the prosecution's lack of findings, going through different routes, yet not doing his own research says volumes. Alex Cifuentes truly had nothing to gain by accusing Avery Becker, I would like to remind everyone. Once again, the defendant's actions truly prove the truth of her words. No criticism can hide the concrete findings that the prosecution has found today. Thank you, Your Honor.
All right, thank you, counsel. That now concludes the evidentiary and argumentative portions of this trial. This case will now be submitted to the jury. the court will be in recess for a few minutes. So congratulations, everybody, on finishing a wonderfully presented trial. What we'll do is we can just keep our cameras off and our mics muted until we get the green light from Bailiff Ham that all of the ballots have been successfully submitted and received by the central scoring room. And then we can turn our cameras back on for just a few brief minutes of critique. I know your next round starts at 4 o'clock. At this point, you're certainly welcome to send chats to each other, to the opposing teams, and congratulate each other if you'd like. And we'll be back. We'll be waiting for Bailiff Ham. Thank you.
I would just like to ask our scorers that once you have submitted your sheet, turn your cameras on, and then I will confirm that we've received all of them.
You guys are good.
Ariana, I saw you had turned on your camera. Are we good to go from you? Okay, it looks like Ariana said that she is having some issues with her video, but I think we are good to move on to feedback, and I will confirm with our hosts.
Okay, so we can proceed with critique.
Yes, I have just been confirmed that we are dismissed after critiques.
Okay, great. Thank you so much. Well, congratulations, everyone. First of all, congratulations on making it to state. That's a wonderful accomplishment for all of you. And then secondly, congratulations on a trial that was very professionally, you presented it very, very professionally. I also, I commend you that we're in the age of COVID, as you know, and so you are surfing online advocacy, which is, that's a skill unto itself. So it's nice to see all of your smiling faces. Very well done. I've actually put myself on a timer here. I'm going to keep myself to 3 minutes. My name is David Schott. I've been an attorney for over 30 years. I was a trial attorney for 20 years. And for the last 13 years, I've run the Center for Trial Advocacy at the University of Denver, their School of Law. So I get to do this every day. I work with our national trial team and I teach trial advocacy 1, 2, and 3 and evidence and advanced evidence and things like that. So I've literally sat in on well over 1,000 mock trials in my life and I love doing this. And I'm I can tell you that all of you did a wonderful job. And I've been judging these for so many years. I've had students in your shoes go finish high school, go through college, come to law school, and be on our trial team. So when you get to that point, please look me up. I would love to. I'd love to see you again. I'm also so please, you can get my email on the DU website. I'm also a principal at Trial Pro. We've created a courtroom simulator. You can find me either place if you or your coaches have questions about any of my my rulings today. On that point, please be sure to thank your coaches and your folks. Your coaches, as you know, they sacrifice hundreds of hours of their out of their life to help you. And the critical thinking skills and the foundations of critical thinking that they're helping you develop will be beneficial to you for your whole life. I actually coached 2 Colorado high schools here for about 8 years, so I know everything that they go through, and it's a wonderful contribution they're making. This is flash advocacy, meaning that I'm making rulings and you're flash frying this whole trial within less than 2 hours, which is a skill that a lot of real trial attorneys don't even have. So again, congratulations on that. I just have 3 quick things that I'm going to mention. First, so much of this is about confidence. So much about advocacy and trial advocacy is about confidence. And I thought all of you did a wonderful job of displaying confidence today. The one example I thought you did very well is whenever there's an objection hearsay. You did such a nice job when you respond. The responding counsel says, Your Honor, this is not hearsay because it's a statement of a party opponent. I thought you did a very nice job with that. One thing, my second point is whenever there's a lack of foundation objection, it oftentimes in real court, it stops the trains. Everyone sort of stops and says, okay, and if it's sustained against you, right? So a quick three little step trick. If you get a lack of foundation objection sustained against you, just then recoil or reset and look at your witness and go, do you know what color the sky? Do you know what color the sky was in Tennessee today? I do. How do you know what the color of the sky was? Well, I was there this morning and I saw it and then I flew here. And now tell us what was the color of the sky. So it's, do you know? How do you know? What do you know? If you can remember those 3 steps, you will never sweat over a lack of foundation objection being sustained against you again. And then, oh, that's my alarm, my 3 minutes. And then my last comment is just, I have a saying that to treat your objections like silver bullets. Save them for the werewolves. Don't just shoot every hairy guy walking down the street. I know it's stupid, and my law school students tease me about it all the time. But I thought that you were very judicious with your objections. Defense, I thought you objected more, but I thought you still stayed well within those boundaries of being judicious. The one thing I would say to defense counsel is you were aggressive on your witness control. That's a personal style for me, and I'm not scoring, so who cares what I'm thinking, right? For me, sometimes, it's a sign of confidence to let a witness, when you say, what color is the sky? And they said, well, it's a little bit windy, it's a little bit cloudy, but ultimately the sky is blue. It's a sign of confidence to let him finish that sentence and then say, so that's a yes. I thought you were slightly aggressive, but again, most important thing I'm going to say today is listen to your coaches. Whatever I say, disregard it and listen to what your coaches tell you, because both squads are obviously excellently coached and they're doing a great job. Those are just some of my 3 quick insights. So with that, I'll turn it over to Hassan. Thank you.
Yeah, so I think everybody did fantastic. I'm actually a law student graduating this semester from DU. But, I was especially impressed with your guys' objections and your guys' cross-examinations. But overall, I think all of you guys did a great job.
Great. Thank you, Hassan. Mary Jo.
This was just so impressive. Thank you so much. I really appreciate the opportunity to participate. I'm a retired attorney. I practiced in business law for 36 years. I went to DU Law, so I'm glad to see we have graduates still. David, I never did litigation, but I really liked on the defense with the cross-examination. I was impressed because that they said, that's a yes, that's a no. But a couple times I did notice that defense counsel did let the client, the witness finish. And I thought, well, that's excellent, because why not? You know, so I thought, just from the person off the street who would be a juror, I never did litigation, that was very effective. And that was used sparingly, and the rest of the time they were pretty assertive, I would say. And I appreciated that. And the fact that, actually, I like the fact that you ruled on objections pretty quickly, but they were good objections. And again, you know, I just thought that everybody stayed in role. A couple times I'm like, oh, I'm going to weep, you know, for a couple of these witnesses. And I really think that the witnesses held up well. All the witnesses held up well under cross. And it was just very, very well done. And you all give me hope.
Yeah, I agree. It's so nice to see that you will be the future of our profession. And on that, I do want to agree with you what you said, Mary Jo, is that witnesses can, great job, because when I used to coach high school, I used to say that it's the attorneys that get you to state, and then it's the witnesses that separate the wheat from the chaff at state. It really is your delivery of your testimony, and we had some really great examples of that today.
It was just good for you, and do thank all the people who supported you, and you know, want to visit with you again when this is over, and you know, your parents want to see you, and it does take a village, and again, it just gives me hope.
Thank you. Ariana.
Yeah, can you guys hear me okay? All right,
Yes.
fantastic. I've got kind of spotty Wi-Fi. My name is Ariana Busby. I am a litigation attorney at Hall & Evans, and I am a DU law graduate. So it sounds like we've got a lot of DU law here. Really fantastic job, everyone. That was amazing to listen to you guys. I've sat through a lot of the regional tournaments, and this was by far the best use of witnesses and exhibits that I've seen. And this is obviously the state tournament, so I'd hope to see that, but you guys were amazing. Really great use of cross-examination on both sides. Really, really fantastic use of objections. Being a litigator myself, I can say that you know, in the real world, you guys probably know civil procedure and evidence better than a lot of practicing attorneys. So you should be really proud of that. And we should all be really embarrassed. Probably brush up on that a little bit more. But yeah, really fantastic job. I'm really proud of you guys, especially doing this in this really unusual virtual environment. I know that couldn't have been easy for you guys, having to do this from your homes, having to do this in a really unusual environment, when all separated from each other, but you guys made the most of this situation and really shown. So way to go.
Excellent. Thank you, Ariana. And the last comment I just want to make is about your level of professionalism, particularly when Exhibit 14 came up and we had differentiated versions of that. I thought both counsel, you handled that excellently. I think you handled it better than many attorneys in real life. But I know you didn't make it adversarial. You worked through it, and I was kind of the one that was making it more complicated. So from the bench, I say thank you for your level of professionalism in how these both sides present itself, and that's not only kudos to you, but that's also a testament to the quality of your coaching that you're getting. So again, everybody, good luck in the tournament. I know you've got 2 more rounds. You've got another round starting in a little over an hour. So thank you so much for everything that you did today for our jurors. Yes, congratulations. Okay, that's it. We're done.
Thank you, Your Honor, and jury
Thank you, Your
members.
Honor.
Thank you.
Thank you very much.
Prosecution thanks you, Your Honor.
You bet.